Rank number
Yes. 50%. It's not
Monday. B group. B group.
Page number 11, page number 58 to 54. Page number 12, page number 55 to 61. Page number 13, page number 62 to 68. Page number 14, page number 69 to 73. For all sides of order. Page number 1.
The complete judgment is in the chamber. They can't release it until I sign it. So, in the result, I affirm the order passed by the tribunal for the reasons stated above and not for the reasons stated by the tribunal. It is however open to the petitioners to institute appropriate proceedings for seeking a declaration that the suit property is their individual property by approaching the appropriate forum. This much is enough. I didn't want to give that liberty. The interim order granted by this court shall continue for a period of 4 weeks. Consequently, this writ petition is allowed. Respondent number 4 is directed to extend the petitioners the pay scales with dearness allowance and house rent allowance commensurate with the post held by them in accordance with the ACT regulations and government orders. Respondent number 4 is also directed to extend to the petitioners the benefits granted under the 6th and 7th Central Pay Commission scales of pay along with allowances from 2012. It is made clear that the respondent number 4 would have to grant the petitioners the benefits of the appropriate pay scale attached and prescribe the ACT post held by them. From 2012, I have said.
For respond number 2 minutes.
It's in the chamber, you can go get it now. In this view of the matter, I find no merit in the petition. The same is accordingly dismissed.
Grateful.
You notice. Vijay to take notice for R1, M Nagai to take notice for R2.
He was brought a managing director of the second responsible corporation. That is where the corporation.
Connected matter is posted on some day.
I know one matter, but it's a review that it is in the next area, please.
No, I think there's a date fixed. There are two other matters like this. State Tourism Corporation, isn't it?
Where was the corporation?
I'll have it on that date.
I'm verified.
I think he's got the date. I'll post it on that particular date. Relist on. I think it's in this week. Not very sure. The date will be given. I think.
Yes, Lord, I have completely made it. That's not it. There is
No. What the?
notice and it's in order.
No, I have not granted an interim order in that
No,
case. No, I'll have it on that day. I'll have it on that day and then consider. I think there was some council appearing for that. AJ to take notice for R1. Shri Sonsu to take notice for R2. Arbati state to take notice for R3. Relist on so and so. Along with 2, 3, 4, 7. They'll give the number on that. Sir, AGA to take notice for respondents 1 to 4. Issue notice to R5 and R6. Council is permitted to take out service on R5 and R6 personally. You notice AGA to take notice for Devraju. MS Devraju to take notice for response.
Number 9.
In matter, no? ಮತ್ತೆ ಯಾರ ಅಪಿಯರ್ ಆಗಿದ್ದಕ್ಕೆ Chandrachud to get notice for respondents. Relist on so. In the meanwhile, of subjections will complete.
Number 10.
What is the next LG?
When we got the order of appointment, commissioner and review of the order of appointment from the court, one of the three has approached challenging an order passed in favor of Canadian. So the point as chairman here.
Chairman of what?
Chairman of the department of party. So from 2018 to 21 was appointed as in charge. However, while after completion of the tenure of 2 years, the syndicate has taken a decision by regularizing the it's not appointed entities it will be on a rotational basis and even as per my instruction, not the responsibility will get another.
You are appointed as what?
I am trying to appoint as chairman of the party.
Chairman of the?
Party.
Please read page 79. Yes. Where is the order passed by this court?
Page 66. It was filed in the year 2021, challenging the order of the third respondent to conduct from 19 to 21. Attention is that in 2 years of service, what they have rendered to be regularized. In fact, the memorandum of petition we can have next is not the relief studies that to regularize the period from 5/7/2019 to 14/2019. It was accorded by the syndicate of your city. Before the completion of this, even as of the date of passing of this order, but I was appointed as the chairman and it was after the notice of this on the court. So that I could review petition. In the review petition order, in this was the election we were copied the stated copy which I have annexed the review in the order of the review.
Then I'll post it along with the review then.
So review is disposed by granting liberty to the petitioner to challenge this order, which is annexed.
Take out notice, let me see. I'll hear them and then pass on.
In case today you need to
I will reinstate you. Why are you worried? I'll hear them and then pass an order. AJ to take notice for R1. Who appears for Bangalore City? V. Ramesh to take notice for R2. Issue notice to R3. Council is permitted. Shri Vijay Kumar Bajantri to take notice R3. Relist.
Yes, I may be permitted to take notice.
I'll have it on Tuesday.
Please.
And ask them not to do anything till Tuesday.
Please.
Okay. Number 11.
You notice. This also to take notice for respondents. Notice each and should take notice. The respondents, relist on. What is unnecessary? You have been transferred. ಸ್ವಂತ ಕೋರಿಕೆ / ಆಡಳಿತ Number 2 now. When were you posted there? But Rakshita to take notice for respondents. For response 1 and 2. Issue notice to R3. Council is also permitted to take out notice on R3 personally. In the next date of hearing, annexure E shall not be given effect.
On the petitioner, my lord. In this matter, we are claiming the family pension. Petitioner husband was working in as a D group employee in Bandur sheep farm. Subsequent to his death, the representation was submitted. In spite of that, family pension was not granted to the petitioner.
What is the reason for rejection?
They have stated that one person by name Siddhamma is specified as a nominee in the paper.
Who is Siddhamma?
Siddhamma is, according to them, it is third wife of the petitioner's husband.
You did not make her a party then. You did not make her a party.
No, she has also expired. 17/6/2005 itself, before death of husband of petitioner, the Siddhamma also died.
AGA to take notice for respondents. Released 2 weeks on date. PC Prabhakar permits that he would be entering appearance for R5 and R6. In matter,
Similar to not the consider by your face connection in your so similar employees on the base job, but is asked that as the issue as a but start to not a very mass is difference in the mass. Only not of course not be taken because they have taken particularly not they have taken it time. So that is the only not way to take mass card. Several people had used fake mass cards and then employment. Later on, they were used for service without and this government will go directed that just for a response. So there were a large number of employees who were produced in DESCOM, whereas there was no order, similar order from DESCOM. DESCOM was allowed to conduct query by DESCOM itself. There was no order to.
but all of them were appointed under the same notification. All of them were appointed under the same notification, isn't it?
But this government for itself in some cases has allowed inquiry to be held by DESCOM. But of course, the facts of this case. The main issue is that the inquiry has been started and the Lordship has directed that inquiry not be kept further until I will replace.
Released on. ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ
Similar matter is there.
Number is ನಿಮ್ದೇ ತಾನೆ?
One matter is right. The other two matters are there, my lord. Similar matters.
Read list on so along with an executive hearing. No further proceeding shall be conducted by the inquiry officer. Date ಕೊಡ್ತಾರೆ. What is the matter about? To take notice for R1, issue notice to R2. Chikmagalur Zilla Panchayat ಯಾರು ಗೊತ್ತಾ? Shri Ashok Naik to take notice for R2. Santosh Naik to take notice for respondents. Relist. Next year. ಸ್ಥಳ ನಿರೀಕ್ಷಣೆ ಎಲ್ಲಿದೆ?
But I was not doing posting. Before that, but yeah, it was not happening. By order period, got 1/11/2022 was placed in the suspension. But on the ground that yes, committed a misconduct by pertaining to election duty. But I approached this one before. This one before allowed me to crash the order of suspension and directed to reinstate. Subject to condition that I shall not involve in election duty. But order is at page annexed D, page 24.
Yes. Yes.
Thereafter, I was promoted annexed page 34. I was not given posting. But ultimately, posting is given annexed page 37.
Yes.
At the revenue of 100, Mahadevapura Vibhaga. I'm given posting. But on the same page, bottom, the chief minister says that I should be relieved to issue the order and the remarks. Special Commissioner Radvin to issue the order. They are not allowing me to permit to join in the transfer place.
Then why are you challenging annexed RH?
I'm not challenging. I'm seeking for a direction to relieve me from the earlier place and permit to join in the after the order. But they have sent a letter to the comment. But the modified order, reason it is that it is not on. But the regular exception, there are the extension of the planet. You cannot be assigned to the exception. Now, the audio where the transfer
take election. There will be election. Therefore, my lord,
There will be election in Yavaga when it Lok Sabha.
there will be election. Therefore, my lord, we have also shown other state. Let's say it's not. We can be posted. Revenue also required. But the government cannot.
ಅಲ್ಲೂ ಎಲೆಕ್ಷನ್ ಇದ್ದೇ ಇರುತ್ತಲ್ಲ.
Okay. Anything about that?
ಅಲ್ಲಿಂಗಿರಲ್ಲ ಲೋಕಸಭಾ ಎಲ್ಲ ಕಡೆ ಇರುತ್ತೆ.
The election duty, election duty. Not a property.
ಅಲ್ಲೂ you can ensure that no election duty is given to them.
Then again for the election duty will have.
No, you can always tell the election commission that this is the order of the court.
Then we have to. Other persons for election.
You have
Election duty and the election officer in detail. Election commission will only issue instructions to the election officer. Election officer in turn will have to make sure.
ಈಗ ನಿಮ್ಗೆ ಯಾವ್ದು ಬೆನಿಫಿಟ್, ಉತ್ತರಳ್ಳಿ ಬೆನಿಫಿಟ್ ಇಲ್ಲ ಮಾದೇಪುರ ಬೆನಿಫಿಟ್? ಅಲ್ಲಿ more beneficial.
But the government officer
At any rate, I will not be involved in the election duty, but
and then there are ideas of other person exclusively for the election. That will be our difficult.
When can you get an order on this?
Government could take it.
Who's to take the decision?
The upper development, but first response.
I in the recruitment rules, the appointing authority is the state government. State government has promoted. The state
No,
government
if the state government modifies the order, there's nothing that you can do, isn't it? If the state government modifies Annex H, there's nothing that you can do. They made a request to the state government to modify Annex H. Because they've given a representation. Until that is considered, Annex H can't be really given effect to.
My submission is not. They request not.
I'll have it next Friday, the direction to them to take a decision on this request of the BBMP. Then you know where you stand. You know what to do now. Relist on.
I said actually, but the chief commissioner himself says.
Correct, but now there's
This letter is also approved.
a memo is filed by the BBMP stating that the government has been requested to modify the posting of the petitioner, and therefore the petition has not been relieved. The copy of the letter addressed to the principal secretary dated 31/20/2023 is also produced. In view of the above, I deem it appropriate to direct the principal secretary to take a decision on the said request on or before so and so. Release the matter and so on. Next. Madam, ಹೇಳಿ principal secretary, don't invite him here again. Relist ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿ ನೀವು ಮಾಡೇ ಮಾಡ್ತಿರಲ್ಲ ಇದ್ದಿದ್ರು ಒಬ್ಬರ Now, what happened to the earlier notification? What I asked, isn't it? You are not challenging annexure C, isn't it?
The first permission. Subsequently, they have a paper publication. If you have done. How by working of this as a J fresh notification. Fresh permission. And they gave the paper publication. The permission as well as the first notification. All of them are pretty much.
No. Read annexure J. Prastavana. ಏನ್ ಮೇಡಮ್ ಕಾರಣಾಂತರಗಳಿಂದ ಅಂದ್ರೆ ಏನು? What is the reason for list? ಆದ್ರೆ ಏನಂತೆ you can always watch that who's R3 and R4? R2 and R3. You notice to R2 and R3, council is permitted to serve the copies of the writ petition on R2 and R3 personally. You want me to recall the order? You want me to recall the order? That's okay. Connected up in the
Another objection raised, since it's disposal on merit IAS.
list. Amended petition is filed. First state amendment ಮಾಡಿಲ್ವಾ? ಈ writ petition amendment ಮಾಡಿಲ್ವಾ? Yes. Next year ಎಲ್ಲ OPS for the respondents. Akhil Venu. ನೀವು ಹಾಕ್ತೀರಾ ಹಾಕಲ್ಲ big sense. Thank you.
Back to the last further matter
ಏನ್ ಮೇಡಮ್
I appear for respondents, Millards, in this matter. I seek a week's accommodation, Millard, to obtain the statutes and for clarification. A week's time may kindly be granted, Millard.
Granted you 10 days time ago on 7th. You only have to make a statement as to whether the diploma college has a sanctioned post of the of an assistant professor.
I will ascertain it and give the appropriate documents. Kindly give 1 week time, Millard, to personal info.
Used.
Obliged. Thank you.
Mixed. Mixed.
Yeah, Ganesh now. Yeah, Ganesh now.
ಮುದ್ದಣ್ಣವ್ರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ ಏನದನ್ನ ಹಾಕೊಳ್ಳ ಮುತ್ತಣ್ಣವ್ರು ಬೇಕಲ್ಲ ಬರ್ಬೇಕಲ್ಲ ಅವ್ರು ಇಲ್ದ್ರೆ ಮಾಡ್ಬಿಡ ಏನ್ ಮುತ್ತಣ್ಣವ್ರೆ ನೋಡಿದ್ರೆ ಪೇಪರ್ ನೋಡಿ
In this case, my lord, my comments are on the affidavit. The honorable was directed to you affidavit stating that he is undertaking to come to the inquiry in 2 months. But instead of 1 month, instead of 5 years affidavit, there is nobody budget that put the document around the affidavit. All documents are not put that you are asking anything. The affidavit was over to the extent that I forward the letter after the every 2 months. That is what is happened. The honorable court has directed. But instead of that, that you are over the that is my question. That is what my no, that is different.
What is the prayer in the petition?
Sanction of drafting or pension.
The interview, what is the main challenge?
Main challenge is sanction of and also back wages I have from the date of dismissal to the date of retirement I have asked for requested for the back wages and to declare a preliminary hearing as vitiated because without paying provision and pensions the inquiry will be vitiated. That is the decision of this court. Can you go through this?
What are the facts of this case?
Facts of this case is the employee, his officer was dismissed earlier. It's a defective inquiry. Inspection was not carried out. And also, for one charge sheet, 2 dismissal orders were issued by 2 different authorities on the same day with the same reference. It is not heard of. So
So with the other irregularities, this inquiry was, this earlier petition was allowed with a condition and started de novo.
Where is that order? Where is that order?
Annexure B, page number petition.
Page number?
50. Page 69.
What happened to the inquiry now?
Please, progress.
June. Actually, now after 6 months completed. This 6 months at our minor, all the documents request were produced. And some documents he requested, then they said, and when the land was doing, he said, I don't want accepted, to send it by district post. Then he said that you don't send it to my GA because I am not able to get it. You send it to a branch, I go and they said, all the documents in branch, and they are not correct. Then he sent one more letter to just done right. Then also did not come. Ultimately, my last year, this document was corrected. And now my lord, this inquiry has become, now I have to see the guidelines, this inquiry has become completed in 6 months. Now, all the 6 months completed, nothing is going. Now that last year, he separated complicated, like that, advocate now. That is rejected. Now, LKC is permitted by right, but they done the minimum for 3 years to complete century. Now, that is what now we have requested for it, provision pension, because we can continue for 3 years, so that we will get pension. In this case, my lord, passing the order, the final report again, therefore the Supreme Court order, my lord. Judgment only that Supreme Court order, very serious, my lord. All those things will be considered after the outcome of the inquiry. That is what this under break number 16, my lord.
Your apprehension is that he will protect the proceedings.
It's a fact because 6 months nothing has happened. Because the next day only they will do the inquiry, appoint the inquiry officer. And he appeared for the inquiry also.
You do one thing, you deposit the provisional pension before this court. Then let us see what he will do. No. They will deposit in the court. You will not get it. You deposit the money in. Correct. Now his prayer is for payment of provisional pension, isn't it? Inquiry is yet to be completed. Your anxiety is that you will protect the inquiry proceedings. Deposit the pension into this court. I will direct him to cooperate with the inquiry and conclude the inquiry within 6 months. Suppose he were to succeed in the inquiry.
2 months. Now the inquiry all completed now. Because instead of that.
ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಮ ಪ್ರಕಾರ inquiry?
Inspection ಮಾಡಿದ್ರು.
ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಗೆ? Deposit.
Inspection and defense documents for the.
Yes, because the
Defense document, I have asked for defense documents. You know, defense documents are the documents which are mentioned in the charge.
If they don't give you the document and ultimately if the report goes against you, you can still succeed because those documents are not given to you. You cannot use that as a tool to. If they don't give it, if they've rejected it, you know what is to be done. But you cannot say that I will not participate in the inquiry because. You proceed. Proceed. Deposit the provisional pension here. Deposit the provisional pension that is entitled to before this court. I will direct him to cooperate with the inquiry and conclude it within 3 months. ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀರಲ್ಲ ಹಂಗ ನಾನೇ ಆರ್ಡರ್ ಮಾಡ್ಲಾ?
This judgment also just my last judgment has been ordered. In this
Mutanore, rightly or wrongly, the order of dismissal is set aside. He is now your employee. He has attained the age of superannuation. You will have to pay him the pension. Since your apprehension is that he will not cooperate, I am giving you a via media. Deposit that money into court. I will ask him to. Money will be here, isn't it? He has more to lose than you. ನೀವು ಎಲ್ಲಾ ಕಂಡೀಷನ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು ನೀವ್ ಆಯ್ತು ಬಿಡಿ, ಹಳೆ ಕತೆ ಬೇಡ. He has now agreed. He has now agreed. I will direct him. I will record his undertaking that he will cooperate with the inquiry.
Inspection of original documents is must be done now. First inquiry only, it is fully in our constitution. That is, we should be permitted 5 days time to inspect the document. Or this particular given and inspected all documents have been reported. And in first year, we are all marking the documents. Now,
you are helping him to ensure that the inquiry does not go on.
But the inspection is a must be done.
Inspection, yes, sir, or inspection?
Inspection,
No, you're helping him to protect the inquiry by all this time. I will record his undertaking that he will cooperate with the inquiry on the condition that he will deposit the project payment into court and the inquiry will conclude within 3 months.
the inspection on the
ಅದೇನಾದ್ರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ರೆ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಆ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ನಾನು ಆರ್ಡರ್ ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡ್ಲಾ? ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ತಾನೆ, ರಿಜೆಕ್ಟಿಂಗ್ ಯುವರ್ ರಿಕ್ವೆಸ್ಟ್ ವಿದೌಟ್ ದಟ್ ಆರ್ಡರ್ ಬೀಂಗ್ ಚಾಲೆಂಜ್ಡ್.
custodian as well documents but they have the instruction to the custodian allow me to inspect that instruction.
You made an application that is rejected. Now what should you do? Hello, can I set aside that order without there being a then at counsel for the petitioner undertakes that he would cooperate with the inquiry and ensure that the inquiry is concluded within a period of 3 months from today. He however submits that the bank may be directed to deposit the provisional pension that the petitioner is entitled to before this court. In view of the said undertaking, the bank is directed to deposit the provisional pension that the petitioner is entitled to before this court. So the undertaking would be the petitioner that he would cooperate with the inquiry and would not adopt any dilatory tactics to protract the inquiry is taken on record. Released 3 months on date. Okay, all the more reason you have to get it closed fast. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ. ನೀವು ಏನು ಮಾಡಿದ್ರೆ ನೀವು ಅಲ್ಲಿಂದ ರೆಕಾರ್ಡ್ ತರಕಾಗತ್ತಾ? ವಿಜಯವಾಡದಿಂದ ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ಗೋಸ್ಕರ ಎಲ್ಲ I passed an order. ನೀವು ಡಿಪಾಸಿಟ್ ಮಾಡಿ. ನೀವು I have recorded undertaking that within 3 months. I can't do that. How can I do all that? No, I'm actually annoyed with this case. This can't go on forever. I should have taken action for. I kept quiet because I didn't want the vice chancellor to be in trouble. But it is like she wants to get into trouble. Second change of counsel. Second change of counsel. Sridhar Aure, I've been more than patient in this case. There's a limit to my patience also. ನಿಮ್ ಸೀನಿಯರ್ ಬಂದ್ರು, ನಿಮ್ ಸೀನಿಯರ್ಗೆ ಅವಮಾನ ಮಾಡಿದ್ರು. ಒಂದಾದ್ಮೇಲೆ ಒಂದ್ ಆಗ್ತಾನೆ ಇದೆ ಕೇಸಲ್ಲಿ.
Because of that, there was some lapse. Not now I have yesterday
ಏನ್ ಮಾಡ್ತೀರಿ 4 ದಿನದಲ್ಲಿ? ತಿರ್ಗಿ ಇನ್ನೊಂದು ಹೊಸದಾಗಿ ಏನಾದ್ರು ತಗರ ತೆಗಿತಾರೆ. This has been happening from the first day the case started. The Vice Chancellor is acting against the orders of the government.
They are sent to the government. Government is also, I cannot know whether they are 100% or not. That is the situation.
ಇಲ್ಲ, ಒಂದ್ಸಲ ಟೈಮ್ ಕೊಟ್ಟೆ, ಯಾರು ಬರ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಅದೇನಾಯ್ತಂದ್ರೆ ಅವರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಕೊಡ್ಬೇಕಿತ್ತು. ಅವ್ರಿಗೆ ಯೂನಿವರ್ಸಿಟಿ ನಾನು ನೋಡ್ತೀನಿ ಅಪೇರ್ ಹಾಕಿ ಕೇಳಿದ್ರು. ಅವ್ರು ಯಾರೋ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಕ್ಕಾಗ್ತಾನೆ ದಯವಿಟ್ಟು ನಾವು ಬಂದಿದ್ದೀನಿ, ನಾನು ಕಳಿಸಿ.
Have you reinstated it?
ನನಗೂ ಈ ವಿಷಯ
ಸೊ ಹಂಗಾರೆ ನನ್ನ ಆರ್ಡರ್ ನೀವು ಡಿಸೋಬೇ ಮಾಡ್ತಾನೆ ಇರ್ಬೇಕು, ನೀವು ಕೇಳಿ ಟೈಮ್ ನಾನು ಕೊಡ್ತಾನೆ ಇರ್ಬೇಕು ಅಂತನಾ? ಅಲ್ಲ, ಹೇಳ್ತೀನಿ. ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಸುಂಗೆ ಫಸ್ಟ್ ಬಂದ್ರು, ಅವರು ನನ್ ಕೈಲಿ ಆಗಲ್ಲ ಅಂತ ಬಿಟ್ಟು ಹೋದ್ರು. ಆಮೇಲೆ ನಿಮ್ ಸೀನಿಯರ್ ಬಂದ್ರು, ಅವ್ರು 2 ಸಲ ಬಂದ್ರು, ಅವ್ರು ಆಗಲ್ಲ ಅಂತ ಬಿಟ್ಟು ಹೋದ್ರು. ಆಯ್ತಾ? ಆಮೇಲೆ ಇನ್ನೊಂದು ಕೌನ್ಸಿಲ್ ಬಂದ್ರು.
ಆಮೇಲೆ ಅವರು ದೇವರಾಜು ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟು ಹೋಗ್ತಿಲ್ಲ. ಅಕ್ಟೋಬರ್
ಇದೆಲ್ಲ ಆಯ್ತು. ನೀವೆಲ್ಲ ಲೇಟ್ ಆಗಿ ಬಂದಿದ್ರ. ಜೋಯ್ಸ್ರಿಗೂ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ. ಸುಳ್ಳು ಅಫಿಡವಿಟ್ ಹಾಕಿ I should have taken action on that very day itself. It was a mistake on my part to let go of the Vice Chancellor. I am still inclined to take that action now. Monday ನಾಳೆಗೆ ಹಾಕೊಳ್ತೀನಿ ಹಂಗಾರೆ. ನಾಳೆ you have to comply with the order or else I will pass some order tomorrow. ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೋ ಬಿಡ್ತಾರೋ, ನನ್ನ ಆರ್ಡರ್ should be complied with. If this is not complied with, there's a consequence. K. Sridhar submits that he has entered appearance today and requests for a day's time. Acceding to his request,
with your lordship's kind permission, extremely sorry to interfere. Now, Sridhar has entered appearance for reasons which I do not want to disclose now. For the reason there was no cooperation, Sridhar has now entered appearance, and therefore I would only request, instead of tomorrow, because I have got some personal link, kindly have it on Tuesday is my only passionate request. Instead of Saturday, kindly have it on Tuesday. That is all my request. If your lordship can,
I have no problem. I have no problem adjourning. If the order is disregarded and deliberately, if there is no appearance on behalf of the university on 2 days,
I'm aware of it. I am not going to vouchsafe that, but your lordship knows that I am going to cooperate with the court. But ನನಗೆ ಸ್ವಂತ ತೊಂದರೆ ಇರೋದ್ರಿಂದ ನಾಳೆಗೆ ನಾನು ಹೇಳೋದು ಮಂಗಳವಾರ ಹಾಕೊಳ್ಳಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಿದ್ದೀನಿ. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಇಂಟರ್ಫಿಯರ್ ಅದು ಇಲ್ಲದೆ ತಾವು
Tuesday. Relist on Tuesday. Senior counsel ಹೇಳಿದ್ದಾರೆ, ನೀವು ಅವ್ರ ಮಾತ್ರ ಹೇಳಿದ್ರೆ relist on Tuesday. Principal secretary in charge, the in charge principal secretary and also the vice chancellor shall be personally present on Tuesday.
I'm grateful to the court now.
36 it is 31. Modern is science college, it is modern is commerce college.
I'm grateful to the court for the accommodation.
I hope that this will stop here.
No, let me see. Because I have my own embarrassing
I
situation.
do not want to pass any remarks which she may have no interest. But if I say something against the Vice Chancellor, it will have a telling effect on everybody, on the whole institution. I am restraining myself despite this kind of deliberate non-cooperation. And you are a party to this, you are a witness to this. You are misused in this position.
Pardon me?
You are also misused by them. By affidavit hakstaralla.
I do not want to say anything now.
Realist. Since case today has ended up here, the name of Vararaju shall be removed from the cost list. Tuesday. Next year. Copy for the ready now? Note. You want to go through the objections?
Next week, state government.
Objections are filed by the university. University alva? By the nursing council. You are appearing for second respondent. For the second respondent. Ready now, madam? You want me to pass an order that the additional chief secretary should be present? Objections act everybody so that I can go further. Then I'll ask him to come. What else can I do? As a last chance, a week's time is granted to the state to file its objections. If the objections are not filed by the next date of hearing, the additional chief secretary, Department of Medical Education, shall be personally present. Released on. Rajendra Kumar Sunghe accepts notice for R3. Hence, payment of process fee is unnecessary. He's granted 2 weeks time to file his objections. Next week, released on.
My lord, proxy counsel for R2 appearing, we just require some time to file our objections, my lord. We have received instructions from the university.
Or yeah.
University last edition also time. No, I don't have to.
That was date 27th.
Much obliged.
32. Chief Minister.
Release by which time objection shall be filed by respondents 2 and 3. ಹಾಕಿದ್ರೆ ಹಾಕಿಲ್ವಾ ಅಲ್ಲ ಯಾವ್ ಬೆಟ್ರು ಎಫೆಕ್ಟಿವ್ ಆಗಿ ಕಾಸ್ಟ್ ಹಾಕ್ಲಾ ಇಲ್ಲ ಇನ್ನೇನಾರು ಮಾಡ್ಲಾ Learned AG submits that extent of justice not be filed since the commissioner was deputed on election duty to Telangana. He requests 2 days time. As the last chance, time is granted till Monday. Tuesday. To file the state objects, relist on. Comply ಮಾಡಿದ್ರಾ? ಏನು ಬಜಾಗಿ? ಏನಾಗಿದೆ ಎನ್ಕ್ವೈರಿ? Dropped. ಯಾವಾಗ ಹಾಕಿದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್?
35 Milord, serial number. Sorry, sir.
Para 3 na.
Page number 3. Last July 24. The charge sheet dated 21.
What is the challenge in the writ petition?
This is mine. And it's not the charge sheet. As per the charge sheet dated 21/11/2009. We had issued legal notice dated 8/7/2010. To the respondent, subsequently the very good thing that the petition was not involved in any of the charges because mentioned charge as the charge petition was filed.
Yeah. Next year, yes. Give a reply. Recovery ಆಗಿದೆಯಾ?
The second paragraph was clarification, second paragraph. It is further mentioned that the first phrase in the report is very practically after 21 like further start for issues of report essentially question the transport related to that. Further you have to pray for.
What is the next year? You?
For issues of the matters. There is response to please theory. Able to understand further the process of the report to promote the
So next year, he and you does not survey for consideration now.
Retired from the service, then that is attempt to the extent of God right.
Then he prayer, to promote the petition to the post of deputy manager with retrospective effect. In survive ಆಗುತ್ತೆ red petition. ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ, ಸುಮ್ಮನೆ ಇನ್ನೇನಕ್ಕೆ ಇಟ್ಕೊಂಡು ಮಾಡುತ್ತೆ. ಏನಾದ್ರು ಇದ್ರೆ ಬೇಡ, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು. ನೀವು ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ ಆಗಿ ಕೇಳ್ತಿದ್ದೀರಾ. ವಾಟ್ ಇಸ್ ದ ಬೇಸಿಸ್ ಫಾರ್ ದಟ್? This court disposed of the writ petition in the absence of the petitioner, taking note of the fact that the charge sheet was of the year 2019 and must have attained finality. Applications are filed for recalling the said order on the ground that the counsel who had entered appearance had fallen ill and was not appearing in the courts. In the statement of objections filed by the respondent, it is stated that the petitioner retired in the year 2010. Yavattu? 13/10/2010. And as a matter of fact, the main prayer of the petitioner regarding the issuance of the charge sheet had been satisfied by the respondents themselves by dropping the charge sheet as indicated in Annexure 3. The other prayers in the writ petition relate to issuance of 3 weeks salary, a show cause notice, and washing an order of transfer, apart from directing the respondents to promote the petitioner to the post of deputy manager. In my view, the said prayers would not survive for consideration, having regard to the fact that the petitioner has attained the age of superannuation way back in the year 2010. The writ petition is therefore disposed of as become unnecessary.
But 35 appear for petitioner, my lord. Matter relating to pay scale of the petitioner. Lord, petitioner.
Next week he wants time.
My lord, it has been heard on several occasions, my lord. The specific date may be given so that on that day.
Relist on 24th.
Oblate.
Here in this case, the Lord petitioner as speaker, the Lord is the name the Lord recommended the Lord for being approval of this appointed. After that, he was appointed, the Lord also opened the Lord as Annexure service is also opened. Annexure gave the Lord. There is also Annexure gave the Lord. There is also a direction the Lord wherein there is a decision taken by the committee that his name should be recommended for the purpose of appointment. That pointed the proposal. No, he has not. I will take submission of that as well because as per my objection statement, proposal response.
Yeah, who are you?
He had filed this. He already filed
ನೀವ್ಯಾರಿಗೆ?
ನಾನು for the management.
You had recommended his case for approval?
Yes, now the magic question is that we have already the proposed respondent is appointed to that case. And on the basis of my submission only.
Last time mark sheet ತೋರಿಸಿದ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಆಫೀಸರ್ ಪ್ರೆಸೆಂಟ್ ಬಿ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes, sir. It is not so. He has not been appointed to the Lord in place.
What is Annexure N? What is Annexure N?
I will submit the Lord. Page 47 application. Page 47 mechanism. The name of the petition is serial number 6. Page 47.
Yes.
Here the Lord, the name of the petition is serial number 6. In the top. Down below, all the three authorities will not go the committee members for the purpose of selection and approval of appointment. I really only last sentence without permission. ಮೇಲಿನ ನೇಮಕಾತಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ಆಡಳಿತ ಮಂಡಳಿಯು ನೇಮಕ ಮಾಡಿದ ಸಿಬ್ಬಂದಿಯನ್ನು ಉಪನಿರ್ದೇಶಕರ ಅನುದಾನ ರಹಿತವಾಗಿ ಅನುಮೋದಿಸುವ ಆದೇಶ ನೀಡಿದೆ ಹಾಗೂ ಈಗಿನ ನೇಮಕಾತಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಮಾನ್ಯ ಆಯುಕ್ತರು ಬೆಂಗಳೂರವರೆಗೆ ಅನುದಾನ ಸಹಿತವಾಗಿ ಅನುಭವದ ಸಹಿತ ಬಹುಮತದಿಂದ ಮಾಡ್ತಾರೆ. Thereafter, Milord Annexure A has been approved. Annexure A is an order wherein the name of the petitioner continues to appear at page number 6 and 349. ಈ ಆದೇಶ
your post was approved. Then what happened?
When my application is my name cannot be sent to the government for the purpose of approval. They say the lot that I have received the resignation now in 2012. That you will also find the lot at page 71. At page 71, item number 5. They don't appoint any person in my place. Page 71, item number 5. ಈ ಶಾಲೆಯಲ್ಲಿ ಶಿಕ್ಷಕರು PCM ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದಾರೆ ಅಂದಿಷ್ಟೇ ಎಂದು ದಿನಾಂಕ 1/12/2012 ಅದನ್ನು ಸ್ವಇಚ್ಛೆಯಾಗಿ ರಾಜೀನಾಮೆ ನೀಡಿರುವುದಾಗಿ ಸಮಿತಿ ಯಾರಿರುವ ಕೋರಿಕೆ ಇದೆ ಅಂತ ಹೇಳಿ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸುವುದರಿಂದ ಕೈಬಿಟ್ಟು ಈ ಹುದ್ದೆಗೆ ಕಡ್ಡಾಯವಾಗಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಅಭ್ಯರ್ಥಿಯಿಂದಲೇ ನಿಯಮಾನುಸಾರ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅನುಸರಿಸಿ ಹುದ್ದೆಯನ್ನು ಭರ್ತಿ ಮಾಡಿ 3 ತಿಂಗಳವರೆಗೆ.
After this annexure N was passed, before that annexure you claim that he retired on 1/6/2012. 2012 you claim that he had resigned.
The vision has already and subsequently we have made a proposed respondent as an
What is the procedure under the Education Act? What is the procedure under the Education Act for a person to resign?
Yes, Lord, kindly see the annexure of 1. Kindly see. This is the resignation submitted by him. Page number 5. Title copy is that. ಗಣಿತ ಶಿಕ್ಷಣ ಶಿಕ್ಷಣ ನನ್ನ ವೈಯಕ್ತಿಕ ಕಾರಣದಿಂದ ನಾನು ಶಿಕ್ಷಕರ ಕೆಲಸ ಮಾಡಲು ಸಾಧ್ಯವಾಗದೆ ವಧುವಾದ ಶಿಕ್ಷಣ ಸ್ವಇಚ್ಛೆಯಿಂದ ರಾಜೀನಾಮೆ ನೀಡಿದೆ.
ಯಾರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರಿ ರೆಸಿಗ್ನೇಷನ್ ಬಗ್ಗೆ? When this letter was when this order of approval was granted the year 2014.
Kindly see the action after this resignation resolution is passed and it has been approved.
Did you inform the authorities and did you take permission to fill that particular post?
Subsequently only I have made this
what is the procedure that is to be followed for appointing?
All the procedures for that, produced all the documents. Whatever the documents, my submission.
When was your first intimation?
Is already been appointed.
It will go. It will go. His appointment will go.
The thing is that
if the approval,
my submission is not like the application is for including himself is pending. Or let there be objection.
why are you arguing on his behalf? You just argue on your behalf. You argue on your behalf. Why are you arguing on
behalf? I'm not arguing on behalf of the institution has made its appointment. That's the reason. Kindly see R3. And here has been the application not proposed. The application was filed.
Your case is that he had resigned.
Yes.
2014 is the approval granted for his post.
Yes.
Why did you not inform the department?
On the temporary basis, on the until like he gets an appointment and some other issue.
So he resigned and yet continued.
No, but this was he has not been freshly appointed. It was only temporary. Was all his request only.
You submitted the proposal for approval of his appointment.
Yes. Earlier we had.
When did you submit the proposal?
I will produce all the documents.
No, who's stopping you? You already filed your objections. I'll go on the basis of that objection.
But what are the documents my learned friend says?
I'm asking you a question. When did you send his application for approval?
No.
Ever?
All the things are used all these. Yes, already in that. It's no more continue to be in our institution. He has worked till 2018, regularly and continuously. His name is also finds as a matter of fact, the order of the commissioner at the next year on 5/9/2015. Is that serial number 6?
The annexure L that is produced indicates that you had submitted the proposal on 7/6/2014.
Yes.
And you claim that he resigned in 2012. Annexure L. ಉಲ್ಲೇಖ 2 ನೋಡ್ರಿ. Sorry, annexure K. Annexure K. ಆಡಳಿತ ಮಂಡಳಿಯ ಪ್ರಸ್ತಾವನೆ ಮೇರೆಗೆ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ ತುರುವೇಕೆರೆ dated 1/3/2014. And there was a spot inspection conducted according to page number 49. ಉಲ್ಲೇಖ 7 ಮತ್ತು 8ರ ಸ್ಥಳ ಪರಿಶೀಲನಾ ವರದಿಯಂತೆ ಶಾಲೆಯಲ್ಲಿ ತರಗತಿವಾರು ವಿದ್ಯಾರ್ಥಿಗಳ ಮಂಜೂರಾತಿ. So this was done in the year 2014. So they found that he was working.
My submission is that it was not.
Sorry?
We have made a fresh appointment of proposed respondent and we have already accepted this institution, but I have used before. Along with my.
What is annexure N now?
Annexure N is the document like which my name may not have been left out to be considered. That is the type page is 58 and my name may not is not found at all in the list at 870.
I will quash this particular clause number 5.
Yes.
And direct that his name be included. Because according to this, Mr. But in 2014, when a spot inspection was conducted, they did not find that he had resigned. And you never informed the department that he had resigned. This is probably some letter that you are misusing now. ನಾನೇನು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ನೋಡ್ರೆ ಡೇಟ್ ಆಮೇಲೆ ಬರ್ಕೊಂಡ್ರೆ ಅಲ್ಲ, would you not have informed them when they come for a spot inspection that this gentleman has resigned?
Now the appointment of the respondent, the proposed respondent has already been sent for action.
That will go.
Election has been done for that. Next is our.
If he does not appear, that means he is not interested. ಇವತ್ತಿಲ್ವಲ್ಲ.
As far as that is concerned,
is your
already appeared to the response.
I cannot wait for him, isn't it?
I am not sure taking any prayer on the behalf of him. But having we have made an appointment of him, that is the reason for that.
No, you may have made an appointment. If he has not resigned, as on 2012, according to the spot inspection conducted by the department, every allegation of yours will have to be discarded. Alva?
No, only prayer is that not consider is the prayer only. If the reference to the designation of item number 6 is concerned as aspect responsible. Second is approval of this appointment. Third is consideration.
What is your objections, madam?
Taken an approval here. My objection statement that number 4. I think he has resigned from the post. He approved the.
When did they inform you? How can you make the statement? It is submitted to the petitioner management of the respondent number 5 has not sent the petitioner name for considering the grant and aid because he has resigned his post on 1/6/2012. You approved his appointment in 2014.
Which the name allowed the service certificate which they just not issued to be in 2015, including the secretary of the institute. A60, and I said, yeah, service certificate.
Tell what? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನಾ ಕೊಡ್ತೀನಿ ಹಂಗಾರೆ ಸಂಬಳ ಕೊಡಿ ಅಂತ. ಇಲ್ಲ ಅದೇ 2 ಸಲ ಟೈಮ್ ಕೊಟ್ಟೆ ಅಲ್ವಾ? ಇಲ್ಲಿ ಬಿಡಿ ಯಾವ್ದು ಹೊಟ್ಟೆಗೆ ಬರ್ಲಿ ಹೊಟ್ಟೆಗೆ ಮಾಡ್ತೀವಿ.
Not a regular form of time, but not junior.
ಇಲ್ಲ ಇವಾಗ ಒಂದೊಂದು ಹೋಗೋಣ. ಫಸ್ಟ್ ಇಟ್ ಪಿಟಿಷನ್ ಅಂತ ಏನು ನೋಡ್ಕೊಳ್ಳಲ್ಲ. You argued the matter already. You argue the matter once.
But two my lord, and I said G, and I said G, my lord,
Yes. Where is the order of promotion?
The next part of
ಇಲ್ಲ ಪ್ರಮೋಷನ್ ಆರ್ಡರ್ ಕೊಡಿ ಫಸ್ಟ್, ಆಮೇಲೆ ನೋಡೋಣ ಪ್ರಮೋಷನ್. ಇಲ್ಲ ನೀವು ಆರ್ಡರ್ ನೋಡ್ಬೇಕು ನಾನು, because this indicates your post was upgraded. Rejoinder to the objections.
That the appointment order.
This is upgradation of post.
This was done by lot in the years 2005-2010. ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ delegates ಅನ್ವಯ ಮಾನ್ಯ ಕುಲಪತಿಗಳ ಅನುಮತಿಯನ್ನು ಜಗದೀಶ್ ವಿವರಣೆ ಇವರೇ ಇತಿಹಾಸದಲ್ಲಿ ವೇತನ ಸಂರಚನೆ ಬಡ್ತಿ ನೀಡಲಾಗಿದೆ.
Therefore, this is an upgradation of the post. It is not a question of you stagnating in that particular tracer or draftsman for 25 years.
I was appointed in
Correct.
2010 I was appointed this. They were not recommended.
The order which enables you for this benefit for 20-25 year services, if you have not got any elevation in your status.
2010 appointment. Now they want to revert it in the next matter. Now remote it
Next matter maditini. First matter.
This is the so far they have stated in the order.
No, this annexure N that you have challenged, there appears to be no merit in that. Annexure G. This order is correct.
Annexure G is not.
You can't get the
already given for further promotion.
ಅಲ್ಲ ನೀವು ಕೇಳಿದ್ ನೋಡಿ ಇನ್ನೊಂದ್ಸಲ ಓದಿ. ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇರುವರಿಂದ ಪ್ರಸ್ತುತ ಡ್ರಾಫ್ಟ್ಸ್ಮನ್ ಮತ್ತು ಟ್ರೇಸರ್ ಹುದ್ದೆಯ ವೇತನದ ಅಡಿಯಲ್ಲಿ 25 ವರ್ಷಗಳ ಸೇವೆ ಪೂರೈಸಿದ್ದು ನಿಯಮಾನುಸಾರ 20 ಮತ್ತು 25 ವರ್ಷಗಳ ಹೆಚ್ಚುವರಿ ವೇತನ ಬಡ್ತಿಗಳನ್ನು ಮಂಜೂರಿ ಮಾಡುವಂತೆ ಉಲ್ಲೇಖ 1ರ ಮನವಿಯನ್ನು ಕೋರಿರುವಂತೆ ಸರಿಯಷ್ಟೇ. ಸ್ಟಾಗ್ನೇಷನ್ ಇನ್ಕ್ರಿಮೆಂಟ್ ಕೊಡಿ ಅಂತ. Which is not true because your post was upgraded and you had the financial benefit for in that upgraded post. So what is wrong with annexure G? No, you will be entitled for this additional increment, stagnation increment, if you had not been given any financial benefit. Your post itself was upgraded, so you are not stagnating.
Chancellor. Chancellor, in the case of Malad, the respondent proposed respondent. In year 2020 itself, Malad recommended.
ಅವ್ರದ್ದು ಬಿಟ್ಬಿಡಿ, ನಿಮ್ದು ಹೇಳಿ ಫಸ್ಟ್, ನಿಮ್ ರೈಟ್ ಹೇಳಿ, ಅವ್ರ ಮೇಲೆ ಯಾಕೆ ನೀವು ಅಷ್ಟು ಇದ್ರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು ನೀವು?
Just to take a revenge against the prisoners.
What is annexure L?
L may not. The Washington file at page 81.
2010 order, you are now doing it in 2023.
After 30 years.
ಮತ್ತೆ 13 ವರ್ಷ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ? 13 ವರ್ಷ ಅವ್ರ ಸಂಬಳ ಇವಾಗ ವಾಪಸ್ ಇಸ್ಕೊಳ್ತೀರಾ? What else will happen now? Read the order. ಪ್ರಸ್ತಾವನೆ ವಿವರಗಳ ಅನ್ವಯ.
ಬಡ್ತಿ ಆದೇಶವನ್ನು ವೇತನ ಶ್ರೇಣಿಗಳನ್ನು ಹಿಂಪಡೆದು
How can you do it after 13 years?
There is no statute. There is no sanction post for that. They were only based on the certificate system that they were upgraded at
You allowed that to stand for 13 years. So now after 13 years.
Yes. Just with the previous
That by itself was wrong, isn't it? You ought not have granted that benefit without the approval of the other concerned. ಅಲ್ಲ ನೀವೆಲ್ಲ ನಾ ಒಪ್ಕೊಳ್ಳಿ, I understand, I can see what is happening. This is done as an offshoot because he filed the writ petition. ಇವರಿಬ್ಬರಿಗೆ ಕೊಟ್ಟಿರೋದು ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ.
ಇದು because they are engineering department. They are
So if I quash this, it will benefit them also. ಅವ್ರಿಗೆ 13 ವರ್ಷನಾ ಬಿಡಿ ಹಂಗಾರೆ ಅವ್ರದ್ದು ಅದೃಷ್ಟ ಅಷ್ಟೇ. You'll save money to that extent.
I just read the rate and we are getting read the entire order. ಪ್ರಸ್ತಾವನೆ ಈ ಸುರೇಶ್ supervisor ಮತ್ತು ಶ್ರೀ ಜಗದೀಶ್ ಡ್ರಾಫ್ಟ್ಸ್ಮನ್ ಮತ್ತು ಟ್ರೇಸರ್ ಅವರು ಮನೆಯ ಕೆಲಸ ಟೋಟಲ್ ವಿಶ್ವವಿದ್ಯಾಲಯ ಡ್ರಾಫ್ಟ್ಸ್ಮನ್ ಟ್ರೇಸರ್ ಹುದ್ದೆಗಳನ್ನು ಪ್ರತಿ ನೀಡಿರುವಂತೆ ಹಾಗೂ ಹುದ್ದೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಮಕ್ಕಳನ್ನು ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ವಿದ್ಯುತ್ ಇಂಜಿನಿಯರ್ ಗ್ರೇಡ್ 1 ಹುದ್ದೆಯ ಸಮಾನಾಂತರ ಹುದ್ದೆಯಾಗಿತ್ತು. ಆದರೆ ಇಂಜಿನಿಯರಿಂಗ್ ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ಮಂಜೂರಾಗಿದೆ. ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪರೀಕ್ಷೆ ಅನುಮೋದನೆ ಒಳಪಟ್ಟು ವೇತನ ಸಭೆಯಲ್ಲಿ 1 ಮತ್ತು 2 ನೀಡಲಾಗಿದೆ. ಸರ್ಕಾರವು SRMS ಪದ್ಧತಿಯನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸಿದ ನಂತರ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆ ಪ್ರಾದೇಶಿಕ ಕಚೇರಿ ಶಿವಮೊಗ್ಗ ಇವರ ಪತ್ರದಲ್ಲಿ ಸರ್ಕಾರದಿಂದ ಉದ್ದವಾಗಿ ಮಂಜೂರಾಗಿರುವ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ವೇತನ ಬಿಡುಗಡೆಗೆ ಶ್ರಮಿಸದೆ ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯ ಹುದ್ದೆಗಳಿಗೆ ವೇತನ ಬಿಡುಗಡೆಗೆ ಶ್ರಮಿಸುತ್ತಿರುವುದು ಕಾರ್ಯ ವಿಧಾನದಲ್ಲಿ ಲೋಪವಾಗಿರುತ್ತದೆ. ಹಿರಿಯ ಸಹಾಯಕ ಇಂಜಿನಿಯರಿಂಗ್ ಹೆಚ್ಚುವರಿ ವೇತನ ಸಲ್ಲಿಕೆಯಾಗಿರುವ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ರಕ್ಷಣಾ ಪ್ರಾಧಿಕಾರದ ಸಭೆಗೆ ಮಂಡಿಸಿ ಸೂಕ್ತ ನಿರ್ಣಯ ಕೈಗೊಂಡು ಸರ್ಕಾರದ ಅನುಮೋದನೆ ಪಡೆದು ಸದರಿ ದಾಖಲೆಗಳನ್ನು ಆರಿಸಿಕೊಂಡು ಶೀಘ್ರದಲ್ಲಿ ತಿಳಿಸುತ್ತಾರೆ. ದಿನಾಂಕ 12/9/22 ದಿನಾಂಕ 27/9/22 ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಲ್ಲಿ ನಿರ್ಮಾಣ ಸ್ಥಳ ಸರ್ಕಾರದ ಅನುಮತಿ ಪಡೆದು ಹುದ್ದೆಗಳನ್ನು ಸೃಜನೆ ಮಾಡದೆ ಮತ್ತು ಪರಿನಿಯಮಾವಳಿಗಳನ್ನು ರಚಿಸಿಕೊಳ್ಳದೆ ಹುದ್ದೆಗಳ ಸೃಜನೆ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಹುದ್ದೆಗಳನ್ನು ಪದೋನ್ನತಿ ಹುದ್ದೆಗಳ ಉನ್ನತೀಕರಣ ವಿಷಯದ ಕುರಿತಂತೆ ರಾಜ್ಯ ಸರ್ಕಾರ ಮತ್ತು ತಾಲೂಕಾಲಕ್ಕೆ ಜಾರಿಗೊಳಿಸಲಾಗಿರುವ ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳದೆ ನೇಮಕಾತಿ ದುರ್ಬಡ್ತಿ ಹುದ್ದೆಗಳನ್ನು ಉನ್ನತೀಕರಣ ಮತ್ತು ಹೆಚ್ಚುವರಿ ಪಟ್ಟಿಗಳನ್ನು ನೀಡಿ ಸರ್ಕಾರ ವಿಶ್ವವಿದ್ಯಾಲಯಕ್ಕೆ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟು ಮಾಡಿದಲ್ಲಿ ಇಂತಹ ಕ್ರಮಗಳು ನಿಯಮಬಾಹಿರವಾಗಿದ್ದು ನಿರ್ಣಯಗಳನ್ನು ತೆಗೆದುಕೊಂಡವರ ವಿರುದ್ಧ ಹಾಗೂ ಜಾರಿ ಮಾಡಿದವರ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು. ಅಲ್ಲದೆ ಉಂಟಾಗುವ ಆರ್ಥಿಕ ನಷ್ಟವನ್ನು ಅವರಿಂದಲೇ ವಸೂಲಿ ಮಾಡಲಾಗುವುದು. ಈ ಸೂಚನೆಗಳನ್ನು ಕಡ್ಡಾಯವಾಗಿ ಪಾಲಿಸುತ್ತೆ. ಈ ಸೂಚನೆಗಳ ಉಲ್ಲಂಘನೆ ಲೋಪಗಳಿಗೆ ಹಾಗೂ ಇದರ ಪರಿಣಾಮಗಳಿಂದಾಗಿ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕುಲಪತಿ ಕುಲಸಚಿವರು ಹಾಗೂ ಹಣಕಾಸು ಅಧಿಕಾರಿ ಹಾಗೂ ಸಂಬಂಧಿಸಿದ ಅಧಿಕಾರಿ ನೌಕರರನ್ನು ನೇರ ಹೊಣೆಗಾರರನ್ನು ಮಾಡಲಾಗುವುದು ಎಂದು ಹಾಗೂ ಆಡಳಿತ ವಿಭಾಗದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಸಿಬ್ಬಂದಿಗಳ ಮಂಜೂರಾದ ಹುದ್ದೆಗಳನ್ನು ಯಾವ ವರ್ಷದಲ್ಲಿ ಎಷ್ಟು ಹುದ್ದೆಗಳನ್ನು ಮೇಲ್ದರ್ಜೆಗೆ ಏರಿಸಲಾಗಿದೆ. ಸದರಿ ಹುದ್ದೆಗಳನ್ನು ಮೇಲ್ದರ್ಜೆಗೆ ಏರಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ಕುಲಪತಿಗಳು ಕುಲಸಚಿವರ ವಿವರಗಳನ್ನು ನೀಡುವಂತೆ ಮುಂದುವರೆದು ಸರ್ಕಾರದ ಬೋಧನೆ ಇಲ್ಲದೆ ಹುದ್ದೆಗಳನ್ನು ಉನ್ನತೀಕರಿಸುವ ಸ್ಥಗಿತಗೊಳಿಸಲಾಗಿದೆ.
So there was no direction to undo what has been done. The direction was to take action against the registrar. That is what it says. ಮತ್ತು ಕುಲಸಚಿವರ ವಿವರಗಳನ್ನು ಅದರ ಮುಂಚೆ ಸದರಿ ಹುದ್ದೆಗಳನ್ನು ಮೇಲ್ದರ್ಜೆಗೇರಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಕುಲಪತಿಗಳು ಮತ್ತು ಕುಲಸಚಿವ ವಿವರಗಳನ್ನು ನೀಡುವಂತೆ ಮುಂದುವರೆದು ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮೋದನೆ ಇಲ್ಲದೆ ಹುದ್ದೆಗಳನ್ನು ಉನ್ನತೀಕರಿಸಿರುವ ಕ್ರಮಗಳನ್ನು ತಕ್ಷಣದಿಂದಲೇ ಸ್ಥಗಿತಗೊಳಿಸಲಾಗಿ ತಿಳಿಸಲಾಗಿದೆ. So they were conscious of this upgradation and they did not ask you to withdraw the upgradation. They only asked you to furnish the name of the officers who were responsible for this. Where is the all direction by the government to degrade them again? Right, next for the next paragraph. Where is the approval refused? They are talking about in future you don't do anything. Give us the name of the officers who have done this. Where is the approval refused for upgradation? ಈ paragraph ಹೋದಲ್ಲ page number 80 ಅಲ್ಲಿ. There's nothing of that kind. They have taken note of the fact that you have committed an illegality. That is all. They have never asked you to undo whatever has been done. They only want you to take action against the registrar. So in order to prevent that, you are undoing whatever has been done. ಅಲ್ಲಿ ಇನ್ನೊಂದ್ಸಲ ಓದಿವಿ ದಿನಾಂಕ 12. You got a problem because of HRMS. Their post was not available. ನೀವು ಅಪ್ರೂವಲ್ ಎಲ್ಲಿ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ? ಸರಿ, ಅದು ನಿಮ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್. ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ದು HRMS ಬಂದಾದ್ಮೇಲಿಂದ ಅವ್ರಿಗೆ ಸಂಬಳ ಕೊಡಕ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಸರ್ಕ್ಯುಲರ್ ಬಂತು. ಇದೆಲ್ಲ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರಿ ನೀವು ಸರ್ಕಾರಕ್ಕೆ, ನಾವ್ ಹಿಂಗ್ ತಪ್ಪಾಗಿ ಹೋಗಿದೆ ಅಂತ. ಅದಕ್ಕೆ ನೀವು ಮಾಡ್ಬಿಡಿ ಇನ್ಮೇಲೆ ಯಾರ್ಯಾರು ಮಾಡಿದ್ರಲ್ಲ ಇದ್ರಲ್ಲ ಅವ್ರದ್ದು ಡೀಟೇಲ್ಸ್ ಕೊಡಿ, ನಾವು ಆಕ್ಷನ್ ತಗೊಳ್ತೀವಿ ಅಂತ ಅಂದ್ರು. ಇವ್ರ ಅಪ್ರೂವಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇವ್ರನ್ನ ಡಿಗ್ರೇಡ್ ಮಾಡಿ ತಿರ್ಗಾ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? All that is different. Where is the approval refused? Approval is not refused. It is prospective. The last two lines of the second paragraph. ಮುಂದುವರೆದು ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮೋದನೆ ಇಲ್ಲದೆ ಹುದ್ದೆಗಳನ್ನು ಉನ್ನತೀಕರಿಸುತ್ತಿರುವ ಕ್ರಮಗಳನ್ನು ತಕ್ಷಣದಿಂದಲೇ ಸ್ಥಗಿತಗೊಳಿಸಲಾಗಿದೆ.
ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯ ಹುದ್ದೆಗಳಿಗೆ ಇದೇ ಸಹಾಯಕ ಹೆಚ್ಚುವರಿಯಾಗಿ ವೇತನ ತನಿಖೆಯಾಗುವ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆಯನ್ನು ತಡೆದು ತಕ್ಷಣ ಪ್ರಾಧಿಕಾರಿಗಳ ಸೂಕ್ತ ನಿರ್ಣಯ ಕೈಗೊಂಡು ಸರ್ಕಾರದ ಅನುಮತಿ ಪಡೆದು ಸದರಿಗಾರಗಳನ್ನು ಆದಷ್ಟು ಶೀಘ್ರವಾಗಿ ತಮ್ಮ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಲು.
So ಅದಾದ್ಮೇಲೆ ನೀವು ಕೊಟ್ರಿ. ಅದಕ್ಕೆ this is the order 27/9/2022 saying that henceforth don't do it. Give me the details of the people who are responsible for this upgradation. You did not give that details. In order to save them, you proceeded to pass this order degrading them, saying that look, we have now rectified the mistake, don't take any action. Approval was never refused. They noticed this irregularity when this HRMS system came about. Therefore, your entire reasoning is wrong. ಎಲ್ಲಿ ತೋರಿಸಿ ನೀವು ಫ್ರಮ್ ದಿಸ್ ಆರ್ಡರ್ ತೋರಿಸಿ, ಪೂರ್ತಿ ಓದೋದಲ್ಲ. Where have they said that withdraw or recall the order by which the posts were upgraded? For 13 years they are in that post. ಇದೆ. ಆದ್ರೆ ಯಾವಾಗ ನೋಡಿ ಇಲ್ಲದೆ ಹುದ್ದೆಗಳನ್ನು ಉನ್ನತೀಕರಿಸಿರುವ ಕ್ರಮಗಳನ್ನು ತಕ್ಷಣದಿಂದಲೇ ಸ್ಥಗಿತಗೊಳಿಸಲು ತಿಳಿಸಲಾಗಿದೆ. Stop ಅಂದ್ರೆ don't do anything further, not undo whatever has been done. I will note that since approval was not refused expressly and this order continued for the past 13 years, it is deemed to have been approved. At least in respect of these people. You can't play around with their lives like this. For 13 years, he was a junior engineer, grade 2. Now he'll go back to a tracer. ಅದಕ್ಕೆ ಅದು ಹೇಳಿದಾರಲ್ಲ, ಅದು ಯಾರು ರಿಜಿಸ್ಟ್ರಾರ್ ಇದು ಮಾಡಿದ್ರಲ್ಲ ಕೆಲಸನ, ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ. ನೀವ್ಯಾರಿಗೆ? You have nothing to say in this. ಇಲ್ಲ, ಇದನ್ನ ಉಳ್ಸಕ್ ಪ್ರಯತ್ನ ಪಡ್ತೀನಿ, ಅದ್ರ ಬಿಟ್ಬಿಡಿ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತೂ ಇಲ್ಲ ನಿಮ್ಗೆ, ಇದನ್ನ ಉಳ್ಸಕ್ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. This order that is produced does not indicate that the government refused approval and government directed you to withdraw the upgradation. So I will hold that there is no reason for you to degrade this particular post and quash this. First petition I will accept that they have no right to challenge the statutes and the order that is passed is correct. ಎರಡು ಒಟ್ಟಿಗೆ ಒಂದನ್ನು ಮಾಡ್ರೆ ಅನ್ಬಿಡಲ್ಲ. You are not able to produce a specific order which says degrade them again. Either way you will file an appeal against this order. Alva. ಅದಕ್ಕೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ನೀವು ಗೆಲ್ಬೇಕು, ಅವ್ರಿಗೆ ಸೋಲ್ಬೇಕಂದ್ರೆ ಈ ಮ್ಯಾಟರ್ ಅವ್ರು ಗೆಲ್ಬೇಕು. ನನ್ನ ಪ್ರಕಾರ ಸಂಬಂಧ ಇದೆ. This is unfair. You can't throw them down. ಅಲ್ಲ, ಏನೋ ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ ಅದಲ್ಲ. ಸರ್ಕಾರ ಹೇಳಿದ್ರೆ ತಾನೆ ಅಂತ ಹೆಸರು ಕೊಡಿ ನಾವು ತಗೊಳ್ತೀವಿ ಅವ್ರ ತರಟೆಗೆ ಅಂತ. Why are you protecting them then? That is a specific instructions that were given by the government. ಸದರಿ ಹುದ್ದೆಗಳನ್ನು ಮೇಲ್ದರ್ಜಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಕುಲಪತಿಗಳು ಮತ್ತು ಕುಲಸಚಿವರ ವಿವರಗಳನ್ನು ನೀಡುವಂತೆ ಕೊಟ್ಟಿದ್ದೀರ ಅದನ್ನ. ಮತ್ತೆ ಫಸ್ಟ್ WP dismissed, second WP allowed. False information.
This was not to say the leading to the objection. The affidavit because the finally petitioner and petitioner because on the floor. State that got page number 6 and page number 7 note. Page number 7 of the this was note 4 and 5, class 4 and 5. That I have not at any time during the period of 5 days. Immediately preceding the date of the application. Is convicted by any court area or any offense involving conduct and sentence in respect to thereof
imprisonment for not less than 2 years. Then next.
So 4 is not wrong. He has not been convicted. No, 4 is not convicted, alva. 4 is not, he is not convicted.
He is not convicted.
Therefore, there's
no proceedings in respect of the offense is alleged to have been committed by him or pending before any criminal court. Let the share the business paper is. What did I can say? That lady, one of the lady, she has filed a case against this man. Under the provision, the first page, not first page, second paragraph, what you can first page against the law.
yeah, the first page.
You have the first statement. It is the second paragraph. It is appeared that the employee by the jurisdiction and filed a complaint against the petitioner before the Equal Police Station on 7/2014 and his said complaint was registered with crime over personal by the judicial police for the offensive punishment under section 50354, 34, 506 of the Education and later the judicial police filed a charge sheet in CC number 8254 of the Chief. Further, the petitioner is charged with saying before the Honorable Karnataka criminal petition number 350 of 2023 and sought for question of the proceedings in CC number 8254 pending before 24 AC of the grand. The Honorable High Court has granted this amount of state and 2023. The appointment of the stamp paper shown to be for the notice dated 8/10/2021 and the same is 2021 R1 number 21 but offenses are very clear. Section 354 of the criminal procedure, the IPC law, it clearly mandates whoever assaults or group of criminal to any woman intended to outrage the.
Please read clause 23 of your conduct rules.
23.
Standing orders. Give me the entire standing orders.
But 23 looks like we have.
So false information regarding name, age, address, father's name, qualification, or previous service at the time of employment. This only regarding these particular things. If he has furnished false information, does it amount to a major misconduct?
Publishing false information. So that is one aspect. Then or suppressing any information regarding the name, date, father.
No, both of them are the same.
Then what you can say. Publishing the false information, that's one class. But then later or suppressing any information.
All of them are relating to. You're reading it disjunctively. It is to be read conjunctively. False information or suppression in respect of these particular facts.
Any information regarding the name, date.
Furnishing false information, anything could be false. Who's to determine whether it's right or wrong? Tell Our Tawal Therapy, they will take action. Why are you worried? They will send it for police verification. You are not able to tell me on what basis you can ask for such an affidavit. That is for them, not for you.
It is not my format itself, I issued it. It is issued with Union, the Minister of the page of the gate code, Government of India, Minister of External Affairs, not page of the gate code. Page right, this is the official memorandum.
Ode, 4 ode.
So, no objection certificate, it was issued in the format connection by the controlling and administrative authority of the employee working at the for obtaining passport by any government service, either or autonomous body, employees at all. NOC submitted passport is issued on the post verification. I have issued no objections, but where is the
Let us see annexure M. Let us see annexure M.
connection?
M. M ತಾನೇ ಅದು. What is your business to ask for an affidavit? Because this was all that was required to be. ದಯವಿಟ್ಟು annexure M ಓದಿ ಒಂದ್ಸಲ. You are now becoming the passport officer. ಮತ್ತೆ affidavit ಯಾಕೆ ಕೊಟ್ರೆ?
Intentionally, you want to pay the invoice for getting the passport, but not apply the passport. Overall, the earlier
Now, who gave you this format for annexure R1?
R1 is the government period.
This is to be given by whom? Annexure I.
Annexure I know that
ಅವ್ರು ಕೊಡ್ಬೇಕಿರೋದು ಪಾಸ್ಪೋರ್ಟ್ ಆಫ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಿರೋದು ನಿಮ್ಗಲ್ಲ.
we are supposed to employee note as a employee note, we have to certify the note.
ಎಲ್ಲಿದೆ ಆತರ?
Annexure I note to be executed appropriate resolution campaign for minimum period. One further said that without the thing to the each period, we are supposed to give. This is format which is issued to the union of period, all this certificate, all without the election. Without means it is a no asset. After verification, all these things are supposed to know.
ತೋರಿಸಿ ಆತರ ಎಲ್ಲಿದೆ?
It is affidavit to the page number 11. Page number 11.
Page number 11 is the affidavit.
Affidavit.
This affidavit is submitted to whom?
But this is the normal affidavit which should be, this central government has submitted all these copies to us. You keep all these copies.
ತೋರಿಸಿ, kindly show from annexure R2 where you are required to collect this.
Annexure B, central government, annexure 10, annexure B, page number 10. All central government employees, state government employees, employees of the statutory bodies and public sector undertakings, their spouse and FPA of 18 years are requested to give an identity certificate. Allow me to know. Not should be considered. Understand who are placed identity certificate. I have read the process for section 16 of the Constitution and certified this is the law contracted. In case of the certificate, I recommend to issue the passport again. It is certified that the organization is central state government public service statutory body to identify. I am property passport act. It should be given to the employer. That I am the employer, the central public sector undertaking. But I was supposed to follow the mandate to section 62 of the passport act.
Section 6, you have to agree with section 6. That's section 6, refusal of passport. Our document is subject to the other court that the passport authority shall refuse to make an endorsement of visiting in foreign country as A, as B, C, and 2A5. Any of the report found in the law. Section 2, section 6(2), subject to the other provisions of that, the passport authority shall refuse to issue the passport to the travel document visiting in foreign country and class D, subsection C,
ಎಲ್ಲೋಗ್ತಿದ್ದೀರಾ?
section 5.
ಎಲ್ಲೋಗ್ತಿದ್ದೀರಾ?
Not section, passport act, not section 6.
6 subsection 2.
Subsection 2, further not section F. All these things should be covered. Section F amendment, subsection F not. Subsection 2.
In what way are you connected with this? They will take action.
That proceeding.
If he has furnished a false information,
Have to cover something, but no objection has to be given after verify all.
on the basis of whatever he has given, you have sent it to them.
No, please, no.
That is again on post verification basis. Merely because you have accepted an affidavit does not mean the passport office will accept the affidavit. That is done only on post verification basis. That is what this clause says. In order to give no objection, you require certain documents. He has, let us say, given a false affidavit. How can that be misconduct? Because that is not 23.
That's why we are passed. Section F also mentioned, section 2, application not that available, not
This petition is filed challenging a charge sheet that has been issued against the petitioner. The only charge, it would be beneficial to reproduce the charge sheet itself. Annexure B. As could be seen from the charge sheet, the allegation against the petitioner was that he had submitted an affidavit for the purpose of obtaining a passport in which he had stated that there were no proceedings in respect of any offense alleged to have been committed by him, which were pending before any criminal court. Though, as a matter of fact, a criminal case had been registered against the petitioner in crime number 31/2020, and in the said proceedings, a charge sheet had also been laid in CC number 8252/2020. Next. The misconduct alleged against the petitioner is referable to clause 23 of the standing orders. 23 alva? Clause 32, subclause 23, which of chapter 7 of the standing orders, which deal with discipline and appeal rules. Clause 32 states that 37 acts mentioned therein would be treated as misconduct. Clause 23, with which we are concerned, reads as follows. As could be seen from the said clause, only if either false information or a suppression of an information regarding A, name, B, age, C, address, D, father's name, E, qualification or previous service at the time of employment or thereafter would constitute misconduct. In other words, only if false information or any information is suppressed regarding the above mentioned 5 items, only then can an employee be guilty of misconduct. Admittedly, in this case, the petitioner did not furnish any false information or suppressed any information regarding his name, his age, his address, his father's name, or his qualification at the time of employment or thereafter. It is therefore clear that the petitioner cannot be alleged to have committed misconduct as contemplated under subclause 23 of clause 32. However, Learned Counsel appearing for the respondent contends that the Union of India had issued an official memorandum dated 26th of May 2015 in relation to issuance of ordinary passport to government servants, PSU, autonomous body. And one of the requirements in the said official memorandum was the issuance of an identity certificate in the format prescribed therein, for which the petitioner was required to file an affidavit. It is contended that since a false affirmation has been made in this affidavit regarding the pendency of the criminal case, subclause 23 of clause 32 of the standing order stands attractive. As noticed above, the misconduct under subclause 23 of clause 32 can be attracted only if there is false information or suppression of information in regard to the 6 elements mentioned therein. The furnishing of a false affidavit for the purpose of obtaining a passport cannot be a ground, cannot be misconduct under the standing orders. Next, it is to be noticed here that the misconduct rules are essentially framed in order to ensure that the conduct of the petitioner in the course of his employment and in relation to his employment are clearly defined. So, assuming that the petitioner has filed a false affidavit in order to secure the passport, it is to be noticed here that the passport officer would issue the passport only after a due verification of the credentials of the petitioner, merely because an affidavit is given by the petitioner in order to secure the no objection of the employer. That cannot be a ground to contend that there's a major misconduct. As already stated, the misconduct should be in relation to the terms of the employment. If the requirement of an official memorandum of obtaining an NOC for the purpose of getting a passport indicates the filing of an affidavit, and an improper or a false affidavit is filed, that cannot be relatable to the terms of the employment of the petitioner. Next, Learned Counsel also sought to contend that under the Passports Act, the passport officer is empowered to refuse the issuance of the passport if there are any proceedings pending before a criminal court. It is to be stated here that the power of the passport officer to reject the application for a passport cannot be usurped by the employer, and it cannot be contended that the petitioner has committed a misconduct. If the petitioner has obtained a false affidavit, has obtained a passport by furnishing false information, it would be open for the passport officer to initiate appropriate action, apart from refusing to issue a passport in any view of the matter, since the filing of the affidavit cannot attract subclause 23 of clause 32 of the standing orders, the charge sheet laid against the petitioner cannot be sustained and same is accordingly quashed. Who's for the respondent? Consider to take corrective and effective steps. ಏನಾಗಿದೆ ಮೇಡಮ್? ಇಲ್ಲ, ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲ ಇದು. ಏನ್ ಮೇಡಮ್ ಇಶ್ಯೂ ಮಾಡೋ ಡೈರೆಕ್ಷನ್ ಹಂಗಾರೆ is there a reason why it's not being implemented? The second respondent has issued the direction, isn't it? Yes. ಏನಕ್ಕೆ ಅಂತ that's why they are ಮತ್ತೆ ಈಗ ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಮಾಡಿ ಅಂತೀರಾ ಕಾಲೇಜ್ನಾಗ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು ಮಿಕ್ಕಿದೆಲ್ಲ ಬಂದಿದ್ಯಾ get instruction relist by which time the state shall file its objections. If objections are not filed, the second respondent yaran barkeli the first respondent shall be personally present before the court. ಹೋದ್ಸಲ 10 ದಿನ ಅಂತ ಕೇಳ್ರೆ 10 ದಿನ ಟೈಮ್ ಕೊಡ್ತಾರೆ.
Next respondent brought as relief from his earlier question on 14th of July brought. Till today he is sitting idle. Not even salary was not taken. My application is there.
You are challenging the order. I will record a statement that your application for posting at Bangalore is ಇವತ್ತೇ ಮಾಡ್ಬೋದು. ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ, ಅವತ್ತು ವಜಾನೆ ಆ ಕಂಡೀಷನ್ ಮೇಲೆ ಗ್ಯಾರಂಟಿ ವಜಾ ಆಗತ್ತೆ. ಅವತ್ತು ನೀವು ಇಫ್ ಯು ಡೋಂಟ್ ವಿಡ್ರಾ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಇಟ್ ಬಿ ಡಿಸ್ಮಿಸ್ಡ್ ಆನ್ ದಟ್ ಡೇ. ಯು ಕಾಂಟ್ ಹ್ಯಾವ್ ಇಟ್ ಬೋತ್ ವೇಸ್. ಯು ಕಾಂಟ್ ಆರ್ಗ್ಯೂ ನೌ ಇಟ್ ಸೆಲ್ಫ್. ಇಫ್ ದೇರ್ ಇಸ್ ಎ ಮೆರಿಟ್ ಐ ವಿಲ್ ಅಲೋ ಯು ರಿಟ್ ಪಿಟಿಷನ್. ಅವ್ರನ್ನ ಕೇಳೋದೇ ಬೇಡ, ನೀವು ಅವ್ರನ್ನೇ ಕೇಳ್ತೀರಿ ನೀವು. Therefore, on that day, if you're ready for a dismissal, I'll adjourn it, or else I'll dismiss it today. ಇಲ್ಲ ಅವತ್ತಿಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿಲ್ಲ ಅವತ್ತು. ಏನ್ ವಾಟ್ ಇಸ್ ದ ಗ್ರೌಂಡ್ ಫಾರ್ ಟ್ರಾನ್ಸ್ಫರ್? $3,700 ಮಾಡಿದಾರಲ್ಲ. And what is the ground? I will record the statement that your request is pending consideration, and I'll direct the authorities to consider and pass orders within a week. That should save your. ಎಲ್ಲಿ ಯಾರ ಫೈಲ್ ಹೆಂಗ್ ಮೂವ್ ಆಗುತ್ತೆ? ನೀವು ಕೊಟ್ಟರೆ ತಾನೇ ಫೈಲ್ ಮೂವ್ ಆಗುತ್ತೆ. Then I'll record your statement and close the matter. Why do you want to keep it pending? Interim action ಮಾಡಲ್ಲವಾಗ. I have granted you more than ನೋಡಿ ಎಷ್ಟು ಸಲ ಕೊಟ್ಟಿದ್ದೇನೆ.
2 ಸಲ ತಗೊಂಡಿದ್ದೀನಿ. From 610, 1310 and 12.
From 3110.
Yes, 3110 ಅಲ್ಲ 1310. 13.
From 610 ಇಂದ ನಡೀತಾನೆ ಇದೆ. Allah, what is the merits in the matter? You argue on that.
Page 27 is the only reason.
Page?
Other,
Therefore, I will direct them to consider your case sympathetically and give you a posting at Bangalore. I will pass an order that will be much better than keeping the petition pending. ಇಲ್ಲ ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಹೈಕೋರ್ಟ್ಲಿಂದ ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. I'll pass an order, a positive order.
That is the directly not the respondent one pass the.
I will do that. An order of transfer is challenged by the petitioner.
The petition is disposed. I do not have bargaining capacity.
The order of transfer has been passed in accordance with the guidelines framed by the state. There can be therefore no infirmity in the said order, at least in so far as the petitioner is concerned. However, when counsel for the petitioner submits that the petitioner's father is suffering from cancer, which is at an advanced stage, and he has therefore made a request for posting at Bangalore. He also submits that the file containing his request is under process, and in all probability, an order will be passed within a week. In view of the above, the writ petition is dismissed. However, a direction is issued to the first respondent to consider the request of the petitioner for continuing him at any place in Bangalore if he has made a request in that regard. Such consideration shall be expedited and shall be considered and disposed of within a period of 1 week from the date of receipt of a copy of this order. If ಅಂತ ಹೇಳಿದೆ ನಾನು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಮಾಡ್ಕೊಳ್ತಾರೆ. He said he has given a representation. If he has given a representation, consider. ಯಾರ ಹತ್ರ ಮಾಡಿದ್ರೆ ಹೇಳಿ ಅದನ್ನ. But if it's not made, he will not consider. That is all. ಎಲ್ಲಿದೆ ಫೈಲ್ ಅಂತ ಹೇಳ್ತಿಲ್ವಲ್ಲ ನೀವು ಅವಾಗ್ಲಿಂದ ಫೈಲ್ ಅಂತ. He is not even a party here. How can they issue a direction to him? The petitioner contends that he has made a request to the government for continuing him at Bangalore. So, if there is such a request made, the same may be considered by the government in accordance with law. Satish, I will not even allow you to make so much of request, isn't it?
That's 43.2 I appear, Manoj, for the petitioner.
What is 43?
Manoj,
That recruitment.
please, Manoj.
Yes.
Registrar of Nursing, Manoj.
Where is Sumana Baliga?
Manoj, I'm told she is unwell, Manoj.
Then approval. Okay. First week, you only have to make a statement whether you want to deposit by yourself or you want an order. If you want an order, I told you it'd be with interest and.
make a decision that we could deposit, and the FPO approved. But in view of the in-charge arrangement till 29, because of the enforcement, because 29 till 29 is only the in-charge arrangement was again changed yesterday.
No, if I adjourn it till first week of December, you'll come back with a negative answer. Why should I keep it pending? I'll pass an order. It's for your benefit that I had adjourned it.
That's what
So the fact that they're not able to take a decision so far indicates that, Alva. Relist on Tuesday. The direction to the principal, it is stated that the principal secretary is unavailable and an in-charge principal secretary has been posted. Leonard AG 6 for time till Tuesday to secure instructions and to keep him present. In view of the above, relist on Tuesday. The in-charge principal secretary as well as the fourth respondent, third respondent shall be personally present.
Number 47, Shiva Mahesh.
And take it up at 2:30. Well, parted matters are. Yalla, I'll take up all the parted matters at 2:30. Bandra, Ravi Shankar Bandra. Get 2:30. Mysore get 2:30 thousand. Tuesday. ಏನಂದ್ರ ಹೋದ್ಸಲ ಡೈಲಿ ವೇಜಸ್ ಆಗ್ತಾನೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಲಾ ರೆಡಿನಾ You are challenging annexure M. M in and O.
After the shortlisting of the petition,
What is annexure M?
annexure M, they withdraw the note and settle stating that a new notification was issued. The reason that the group 3 there is no any women candidate. It is a page number 38 customer made 38 page number 3 other lead of the paragraph. Then there's a page number 37 last paragraph. Backlog extension name makati adiyeni sahaya pradana master list ಈ ಅಧಿಕಾರಿಗಳ ಅಭ್ಯರ್ಥಿಗಳ ಅರ್ಜಿದಾರರು ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕ ಜೊತೆಗೆ 3 ಜನ ಪುರುಷ ಅಭ್ಯರ್ಥಿಗಳು ಅವರ
Where are you reading? ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? ಎಮ್ ಏನ್ ಹೇಳುತ್ತೆ?
Emily, they withdraw the note earlier 26. Notification, Article 16 notification, they withdraw. And once again, fresh notification was issued. And the reason that there is no any movement candidate by the application for the purpose. The last paragraph.
You selected the order at page 33. 33. The order passed on the last occasion. No, read para 3.
Case of the petitioner is pursuant to the notification issued to the respondent number 2 for appointment against the backward post. The petitioner has been made an application on 26/2016. As the petitioner is eligible candidate for appointment against the backward. He was called for the interview and he was selected. His education selected. His educational certificate, experience certificate was verified. This is his contention. Contention. Before this, just contention. And certificate. Notification. The notification was called on 26/2016. But there were two mistakes in that said notification. One was with regard to the education qualification, and the other was with regard to there were 3 posts for gender. That is, one was for ST women, the other 2 was ST others and ST women. Instead, after doing all the process, he was not still selected. The list was prepared. As per the list, they did not consider ST others. For this reason, the appointing authority did not accept the notification, that selection, whatever. They did not. It was not communicated to anyone. Because then we requested the government to recall the order, to recall the notification, as the education qualification was wrongly mentioned in the notification, and we wanted to give the fresh notification in accordance with law and the C&R rules. As per that matter, government approved us to recall the notification which was wrongly given and give the fresh notification. Based on that matter, we recalled the order. We recalled the notification on 7/1 as per the 7/1/2016, 2019. We recalled the order and passed the fresh notification. As per that matter, now they have selected the candidates also on their own. There was no stay.
Implement them then. No, if you have to succeed, should they not be heard in the matter? They will lose their jobs, isn't it, if you succeed?
Yes. But they have mentioned, Nanisha, they have stated, there is no need of paying this application. They was participating in para 3, they were participating. Was that maybe
Yes.
Sorry, annexure P.
Yes.
Annexure P, they never participated. Was that the only thing they were never participated? So, what article that was the Dinaka, Patan, we are to get from Group 3 Karnataka.
Have you considered his case?
This is the request which we have made to the government. It is not the order. It is the request what he is giving.
Where is the approval grant by the government?
My objections.
Did he apply under the new notification?
No, my lord, he did not apply. And also he was not eligible because he has not completed diploma. He has done only SSLC and ITI. He is not eligible. My lord, page number 13. Sorry, page number 13.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲ,
ನಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್
ಅದೇನೋ ರೆಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಅಂತ ಹೇಳುತ್ತೆ ಅಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 13. is part of that recruitment and promotion rules. Additional objections in Akara.
Our amendment, after we giving the endorsement telling that we have approached the government for recalling the notification.
Yes. ಇಲ್ಲ ಹೊಸದಾಗಿ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ. But to reject that applications, your recommendation was to also consider the application that already filed. The ultimate request was permit you to withdraw that to issue a fresh notification. That is granted. The recommendation that you sought, that you made.
It is not answered that. However, the application filed by petitioner is with regard to, he has only done his necessary and ideal. That cannot be considered because the fresh notification is with regard to diploma. They have to complete diploma.
Where is the recruitment rule to that effect?
That is at page number 14.
Of this additional objections? Yes.
Page number 14, 19, 11. 19 and 8. Classification of post to grade others. Otherly, into grade 3, group 3, 6th column. Otherly, welder.
Yes.
Hello, group 3. Kindly come to page number 21. 7.3, second class, 7 point. The degree diploma holders in the respective discipline will be included in wage group 3, skilled category in the technical department.
Where is the educational qualification?
Degree diploma holders. 7 point, please. That phrase is.
No, you have said there is induction of unskilled workmen or attendants will be in wage group 1. Correct.
Wage group 1, 7.1. 7.2.
7.2 induction of semi-skilled workmen. Who is a semi-skilled workman according to you?
No, here they have.
Is there a definition? Is there a definition of a semi-skilled workman?
Column 7.
What is the definition of a semi-skilled?
Page number 19.
No, I understand this. A welder is called, it's skilled. Unskilled.
Next to skilled. Unskilled. Semi-skilled.
So attender, helper worker is unskilled. So he is a skilled operator.
Skilled is diploma. Instead of this, they have given the wrong education qualification. So it was withdrawn. And then question of as per the annexure team, they in page of fighting, they made me not to pay the though I have not taken I don't
No, if the notification is withdrawn on the ground that the qualifications prescribed therein are not commensurate with the rules, how can you say it is wrong?
The reason by rejecting as per the annexure that women candidates are not.
No, that is for backlog vacancy. One of the reasons given by them is also that the notification that had been issued did not prescribe the correct education qualification, isn't it? M is only seeking for approval, alva.
Really, I'm saying everybody. Background position ಅಡಿಯಲ್ಲಿ
where is the request regarding the qualification?
In page number 41, they have written a letter to the government telling that for what reason it has to be recalled.
In this, pursuant to the order of this court, Annex M was passed, isn't it?
Yes.
In this, where have you mentioned that it should be recalled?
It has to be recalled. No, we have mentioned.
In this particular endorsement that you gave him, you're only talking about backlog vacancy.
Yes,
You did not raise anything about the education qualification. Where have you said in this endorsement that you gave, pursuant to his representation, that the notification was proposed to be recalled because it did not prescribe the correct qualification? That is an afterthought, isn't it?
What is there?
You should have said so in Annex M.
No, that is the endorsement which we have given to you.
So in the endorsement, what did you say? There was a problem with backlog vacancy. Kindly come to page 37, the last paragraph. Page 38 ನೋಡಿ SC ಮಹಿಳೆ ST ಸಾಮಾನ್ಯ ST ಮಹಿಳಾ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ವೆಲ್ಡರ್ ಹುದ್ದೆ ಮೀಸಲಾಗಿರುತ್ತದೆ. ವೆಲ್ಡರ್ ಹುದ್ದೆಗೆ ವರ್ಗೀಕರಣ ಮೀಸಲಾತಿ ಪ್ರಕಾರ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಗುರುತಿಸದೆ ತಪ್ಪು ಗ್ರಹಿಕೆಯಿಂದ 3 ಜನ ಪುರುಷ ST ಅಭ್ಯರ್ಥಿಗಳನ್ನೇ ಗುರುತಿಸಿರುತ್ತಾರೆ. ಇದರಿಂದ ಮುಂದೆ ಆಡಳಿತಾತ್ಮಕ ಹಾಗೂ ಕಾನೂನಾತ್ಮಕ ತೊಡಕುಗಳು ಉದ್ಭವಿಸುವ ಸಾಧ್ಯತೆಗಳು ಇರುವುದನ್ನು ಮನಗಂಡು ದಿನಾಂಕ 26/2/2016 ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕ ವೆಲ್ಡರ್ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸಿ ಹೊರಡಿಸಿದ ಜಾಹೀರಾತು ಪ್ರಕಟಣೆಯನ್ನು ರದ್ದುಪಡಿಸಿ ಖಾಲಿ ಇರುವ ಒಟ್ಟು 6 ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳಿಗೆ ಹೊಸದಾಗಿ ಜಾಹೀರಾತು ಪ್ರಕಟಣೆಯನ್ನು ಹೊರಡಿಸಲು ಸರ್ಕಾರದ ಅನುಮೋದನೆ ಕೋರಿ ದಿನಾಂಕ 17/1/2017 ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. ಹೊಸದಾಗಿ ಹೊರಡಿಸಿರುವ ನೇಮಕಾತಿ ಜಾಹೀರಾತು ಪ್ರಕಟಣೆಗೆ ಸ್ವೀಕೃತವಾಗುವ ಅರ್ಜಿಗಳ ಜೊತೆಗೆ ಈಗಾಗಲೇ ದಿನಾಂಕ 26/2/2016 ಜಾಹೀರಾತು ಪ್ರಕಟಣೆ ಅನುಗುಣವಾಗಿ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕರ ವೆಲ್ಡರ್ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಹೊಸ ಜಾಹೀರಾತು ಪ್ರಕಟಣೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲವೆಂಬುದರ ಬಗ್ಗೆ ಸಹ ಸರ್ಕಾರದ ಅನುಮೋದನೆ. Where did you say that the notification was sought to be withdrawn? Because
This endorsement we have not told.
then
No. As per the CNR rules, it is the welder.
That is
No, if we are not rectifying that, then where we inform. It is.
ಇಲ್ಲ, ಇವಾಗ ಏನ್ ಗೊತ್ತಾ, ನೀವೇ ತಪ್ಪು ಮಾಡ್ಬಿಟ್ಟು ಬೇರೆಯವ್ರ ಮೇಲೆ ತಪ್ಪು ಕೂರಿಸ್ತಿದ್ರ. You kind of gave him an impression that you had.
But we are not told that.
Where is this? Where is the 17/1/2017 communication, which is referred to at page 38?
17/1/2017.
Yes.
41.
Page?
Page 41. Annexure, please.
ಅವಾಗ್ಲೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ನಿಮ್ಗೆ ಅರ್ಜಿ ನಿಮ್ ಸೆಲೆಕ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ನಿಮ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಅಂದ್ರೆ ಕೆಲಸ ಮುಗ್ದಿತ್ತು.
Annexure, please.
ಅಲ್ಲ, ಅವ್ರು ತಿಳಿಸಿದ್ರೆ ಆಗ್ತಿತ್ತಲ್ಲ. You should have told him. You also kind of informed him that you don't have to apply afresh because you are charged for approval of the government for considering the application is already filed. Therefore, you accepted that he possessed the education qualification. If you were to recommend to the government that we will accept the applications that are already filed and consider them, that means you are saying that the education qualifications were satisfied.
If it is satisfied as per our CNR rules,
you should have said so in this endorsement. You are playing around with this life.
Notification is not there. If the notification is wrong, they have withdrawn that with the bona fide reason that.
Bona fide ನಿಮ್ಮ ಹತ್ರ ಇದ್ದಂಗಿಲ್ಲ.
Bona fide.
ಆಮೇಲೇನು?
It is not so. In this matter, page number 42, on 17/1/2017 only they have mentioned that
there is this mistake. In page number 38, they have already informed that on 17/1/2017, we have written letter to the government. In that government letter, they have clearly mentioned that this is the.
Where have we said in the 17/1/17 regarding?
Page number 42.
Yes. Yes.
ದಿನಾಂಕ 10/7/2012 ಜಾರಿಗೊಳಿಸಿದ ಕಾರ್ಮಿಕ ವರ್ಗದವರ ವಿರುದ್ಧದ ನೇಮಕಾತಿ ಮತ್ತು ಮುಂಬಡ್ತಿ ನಿಯಮಗಳ SSLC ಜೊತೆಗೆ ITI ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ನಿಗದಿಪಡಿಸಲಾಗುತ್ತದೆ. ಹಾಗೆ ಖಂಡಿಕೆ 7.3ರಲ್ಲಿ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕರ ಹುದ್ದೆಗಳಿಗೆ ಪದವಿ ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿ ವಿದ್ಯಾರ್ಥಿ
ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? Where are you reading?
42, page number 42 of the registration. Second line, third line.
ದಿನಾಂಕ 10/7/2012 ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಅದೇ.
No, you were aware that it was reduced. You admit, kindly read from para 2. ದಿನಾಂಕ 10/7/2012.
ದಿನಾಂಕ 10/7/2012ರಿಂದ ಜಾರಿಗೊಳಿಸಲಾದ ಕಾರ್ಮಿಕ ನೇಮಕಾತಿ ಮತ್ತು ಮುಂಬಡ್ತಿ ನಿಯಮಗಳ 2012 ಖಂಡಿಕೆ 7.2ರಲ್ಲಿ ಗ್ರೂಪ್ 2ರ ಕಾರ್ಮಿಕರ ಹುದ್ದೆಗೆ SSLC ಜೊತೆಗೆ ITI ಅಭ್ಯರ್ಥಿಗೆ ವಿದ್ಯಾರ್ಹತೆ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಹಾಗೆ ಖಂಡಿಕೆ 7.3ರಲ್ಲಿ
ಅದಾದ್ಮೇಲೆ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕರ ಹುದ್ದೆಗೆ ಪದವಿ ವಿದ್ಯಾರ್ಥಿ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ನಾವು read the next.
ಅಭ್ಯರ್ಥಿಗಳು ಲಭ್ಯವಾಗದ ಕಾರಣ ಈ ವಿದ್ಯಾರ್ಥಿಗೆ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಿ ಗ್ರೂಪ್ 2ರ ಕಾರ್ಮಿಕರ ಹುದ್ದೆಗೆ ನಿಗದಿಯಾದ SSLC ಜೊತೆಗೆ ITI ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿದ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಲು ಸಮಾಜ ಕಲ್ಯಾಣ ಇಲಾಖೆಯಿಂದ ದಿನಾಂಕ 16 ಅಭಿಪ್ರಾಯ ಪಡೆಯಲಾಗಿದೆ. ಅದರಂತೆ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕರು ವೃಂದದ ಹುದ್ದೆಗೆ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು.
So therefore, you were aware when you issued the notification as to what was the requirement. Because nobody came, you requested the social welfare department to allow you to reduce or relax the education qualification. That was agreed upon.
No, it was not agreed.
ಅದೇ ಬರೆದರೆ ನೋಡಿ, ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಲಾಸ್ಟ್ ಲಭ್ಯವಾಗದಿದ್ದಲ್ಲಿ ಹುದ್ದೆಗಳಿಗೆ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಸಡಿಲಗೊಳಿಸಲು ಅವಕಾಶ ಕಲ್ಪಿಸಿದೆ. ಅದರಂತೆ ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಹತೆಯಲ್ಲಿ ಸಡಿಲಗೊಳಿಸಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಬಹುದೆಂದು ಸೂಚಿಸಿರುತ್ತಾರೆ. Therefore, you reduce the qualification. You are making out a new case now. Therefore, you cannot bring the ground of education qualification now.
Education qualification as per the CA.
Once you had obtained this relaxation from the social welfare department regarding education qualification, you cannot issue a fresh notification contrary to the permission granted. That is what it says. It is clear.
I understood.
29/10/2015 ಮತ್ತು ಅಭಿಪ್ರಾಯ ಪಡೆಯಲಾಗಿದೆ. Understood. However, I take instructions and come back with regard to the other, this one is, they have not considered SC category while giving the this one. That is, here in the same there is number 42.
Now you have appointed a SC woman.
No, SC women we have not appointed. SC men we have appointed.
The earlier indication was that you should kindly come to page 42.
Please, 42, please.
The backlog ವಿಶೇಷ ನೇಮಕಾತಿ ಅಡಿಯಲ್ಲಿ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕ ವೆಲ್ಡರ್ 3 ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಮಾಸ್ಟರ್ ಲಿಸ್ಟ್ ಅನ್ನು ಹಾಗೂ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ವರದಿ ಸಲ್ಲಿಸಲು ರಚಿಸಲಾಗಿದ್ದ ಅಧಿಕಾರಿಗಳ ಸಮಿತಿ ಅಭ್ಯರ್ಥಿಗಳ ಅರ್ಜಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಗ್ರೂಪ್ ವೆಲ್ಡರ್
3 ಜನ ಪುರುಷರ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಅರ್ಹರೆಂದು ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಈ 3 ಜನ ಅಭ್ಯರ್ಥಿಗಳು ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಸೇರಿರುತ್ತಾರೆ.
ಆಮೇಲೆ ಮೀಸಲಾತಿ ಪ್ರಕಾರ
3 ಹುದ್ದೆಗಳು, ಒಂದು SC ಮಹಿಳೆಗೆ, ST ಸಾಮಾನ್ಯ, ST ಮಹಿಳಾ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ವೆಲ್ಡರ್ ಹುದ್ದೆಗೆ ಮೀಸಲಾಗಿದೆ.
So the fresh notification should have been only for SC female, ST general and ST female.
The notification was like this only. Fresh notification was also like this one. Mainly come to my objections.
Now you have again gone against your notification appointment.
Mainly come to my.
Have you appointed scheduled caste female?
Female we did not appoint another for this reason. They have mentioned in our and kindly come.
They were unavailable anta.
Not available. Page number. Kindly come to page number 39.
So he would have applied. Did you inform him? No. Did you inform him after this? You had told him that ಅನುಮೋದನೆ ಖಾತೆಸರಾಗಿದೆ, government ಅನುಮೋದನೆ for considering the application which have already filed. Also along with the present notification, should you not inform him the government has refused, you'll have to apply afresh.
Government has refused for fresh. My lord, it was before the court, my lord. I have filed the application. It was before the court. This petition only was before the court.
Did you tell him? Did you make an application in this court asking him to file a fresh application?
You have not done, my lord, telling them to file fresh. Because education qualification was also a part of that.
That is not right now.
My lord, can you come to page number 39? My lord, that is the ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳ ನಡುವಳಿ. Page number 13. My lord, they have not appointed.
Page 39 of?
My objection.
Yes.
My lord, now what we have done is we have appointed 3 men, SC 1 man instead of women, for the reason that they have not applied it. But in the previous notification we did not do that. In ST only we appointed 3 people, not appointed. They choose for 3 people in ST only. But in this case we have not done that. For the reason that ST women was not available, SC men was available.
So he would have been eligible.
ST available, ST.
ನೀವು ST na? ST female ಒಂದಿತ್ತಲ್ಲ?
Female ಇದೆ. ಅದಕ್ಕೆ ಇನ್ನೊಬ್ರು ಬಂದಿದೆ. ಅಲ್ಲ. ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ.
If that order, if that qualification goes, if the social welfare department had allowed you to relax for that one notification, how can you again issue a fresh notification for a different qualification? You are playing around with his life. You informed him categorically that because the requested application was not forthcoming from scheduled caste, you had requested the department to reduce the qualifications, relax the qualifications. It was agreed upon and you had issued a notification. But the second notification that is issued goes back to the original notification.
As the reason here is take instructions The reason we cannot reduce qualification for the reason that
You already did.
That's what they request for the government what they have.
And it was
done,
granted.
clearly telling that.
It was granted and you acted upon that.
My lord, I take instruction on that, my lord. However, my lord, as per the CNR rules, my lord, it is the vendor.
Correct, but you yourself say that that was not beneficial to you because nobody was applying. So you keep changing the qualification whenever it suits you.
My lord, I will take instruction with regard to that, my lord. And for the two objections, what I told, one objection is this one. With regard to SC/ST.
Like ST female appoint madilla.
Madilla. SC female.
Because it was unavailable.
Unavailable.
Nobody had applied.
No one has.
He would have been eligible under that old notification.
Qualification is coming.
Then if you have got permission for the old notification to reduce the qualification, who gave you permission to increase it again?
Government only has.
Government.
Not increase, not for increase, because they are already in the.
Correct, but it was your view that you are not getting applicants, therefore we want to relax. He had the benefit there.
My lord, instead of amending the CNR, how we can go and reduce the. There is a mistake, my lord.
There are rules, recruitment rules which say that in case of SC/ST candidates, if they do not possess the requisite qualifications, it is open for the authorities to. ಅದರಲ್ಲೇ ಕೇಳಿದ್ ನೀವು ಆ ಪವರ್ ಕಡೆ ಕೇಳಿದ ಆ ಪವರ್ ಕಡೆ ಅವ್ರು ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡಕ್ಕೆ ಅವಕಾಶ.
10.2 is for some other.
No, you check up. There are recruitment rules in respect of backlog because this problem arose, saying that there are no eligible candidates available. In such cases, the government orders to the effect that the authorities are empowered to relax the qualifications, just to ensure that they come in. Now you are acting exactly opposite to that. You are keeping them out.
They have not gone beyond that backlog post to whom it has to be given. They have not gone beyond that.
You have prejudiced him.
My lord, it is for the reason that education, my lord, I will take that. However, my lord, but not for the qualification, my lord. Then for the SCS, as reservation was not corrected.
The relaxation, no, if it is to be for all the notifications, they only said. According to you, the reservation backlog vacancy was not correctly specified. Therefore, you wanted to re-notify. That was granted. The government did not grant you permission to modify the qualifications.
You have not modified.
You have. The earlier one was SLC. Now it has become diploma.
As to the CNR rules, it is diploma. You cannot go.
ನೀವು ಹೆಂಗ್ ಬೇಕೋ ಸೆಲೆಕ್ಟಿವ್ ಆಗಿ ಹುಡುಕ್ತಿದ್ರ ಅದು ಫಸ್ಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆತರ ಇರಲಿಲ್ಲ ತಾನೆ CNR ರೂಲ್ಸ್ ಪ್ರಕಾರ. ಆ ನೋಟಿಫಿಕೇಶನ್ ವಿತ್ಡ್ರಾ ಮಾಡಿ ಫ್ರೆಶ್ ನೋಟಿಫಿಕೇಶನ್ rectifying the reservation category was all that was done. ತೋರಿಸಿ ಅದರಲ್ಲಿ. That's why I made you read that particular 71/2017.
Both they have mentioned.
No, ಇನ್ನೊಂದ್ಸಲ ಓದಿ. Forget about new notification. The reason for you to withdraw the earlier notification was only one. Backlog vacancies ಸರಿ ಹೇಳಿರಲಿಲ್ಲ ಅಂತ. In that order, you have stated that qualifications had been relaxed pursuant to the suggestion by the Social Welfare Department. You never requested the government to issue a notification prescribing the correct qualifications.
Our request, kindly take page number 36 of our statement of objection.
71/2017 ತೋರಿಸಿ ಅದೇ ತಾನೆ. Page 41.
2018
You don't keep changing. 71/2017 ನೋಡಿ first.
2/11/2018 ನಾವು request government kindly come to my objection.
ಅವನಿಗೆ ಒಂದ್ ಹೇಳಿದ್ರಿ 17/1/17 ಕೇಳಿದೇನಪ್ಪ, ಅದು ಅಪ್ರೂವಲ್ ಬಂದಿದ ತಕ್ಷಣ ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ರೆ.
That is 17/1/2017. Kindly come to page number 36 of my objection.
Yes.
Kindly come to the previous which we read now. Just now. Page number 41. There was some confusion. ದಿನಾಂಕ 10/7/2012. That was not the notification. 10/7/2012. That was not the notification.
sorry, the notification dated was 26/2/2016, not 10/7/2012. 26/2.
What was the notification which was without the first notification?
26/2/2016.
Where is it? Where is it?
Sorry, there was something.
Because 17/1/2017.
It is not difficult that we have not placed, but it is not difficult that 26/2/2016 notification.
Come back to page 41. We read paragraph 13, the third paragraph, right?
41.
41.
Please.
The reason for relaxation is given in paragraph 3. ಅದರಂತೆ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕ ವೆಲ್ಡರ್ ವೃಂದ 3 ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ದಿನಾಂಕ 26/2/2006 ಹೊರಡಿಸಿದ ಜಾಹೀರಾತು ಪ್ರಕಟಣೆಯಲ್ಲಿ. So 2016 notification was issued after you got the relaxation from the welfare department.
No, 2016. By giving the 2016 notification, we have not taken any approval from the government or from the welfare department with regard to this notification.
I'm not talking about 2019 notification.
16 notification we have not taken.
Kindly see para 3 once again. The first line of fourth paragraph says, paragraph 3 talks about relaxation.
This is
that is the C&R rules 2012.
This we have not referred to. This reason.
Then you correct ಓದಿ ಅದನ್ನು. Paragraph 3 talks about the need to reduce the educated qualification. After that was given, fourth paragraph first word says ಅದರಂತೆ ದಿನಾಂಕ 26/2/2006 ಹೊರಡಿಸಿದ ಜಾಹೀರಾತು. So 26/2/2016 notification was issued pursuant to the permission granted by the department. He was eligible there.
Can you come to page number 36 of my objection? 37 objection.
Next year.
Next year.
Yes. This is 2019. Page 36. Yes.
Last term, that is certification.
Yes.
ಹೊರಡಿಸಲಾದ ನೇಮಕಾತಿ ಪ್ರಕಟಣೆಯಲ್ಲಿ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕ ವೆಲ್ಡರ್ ವೃಂದದ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಸೇರಿದ 1 ಹುದ್ದೆ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಸೇರಿದ 2 ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸಲಾಯಿತು. ಈ ಅಧಿಸೂಚನೆಗೆ ಪ್ರತಿಕ್ರಿಯಿಸಿ 15 ಅಭ್ಯರ್ಥಿಗಳು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದರು. ಈ 15 ಅಭ್ಯರ್ಥಿಗಳ 18ರಿಂದ 29 ಕೆಲವು ಮಾನವ 6 ಅಭ್ಯರ್ಥಿಗಳಿದ್ದು ಸೋಮವಾರ ದಿನಾಂಕ 10/7/2012 ಜಾರಿಗೆ ತಂದಿರುವ ಸಂಸ್ಥೆಯ ವೃಂದ ನೇಮಕಾತಿ ಮತ್ತು ಮುಂಬಡ್ತಿ ನಿಯಮಗಳ ಪ್ರಕಾರ ಗ್ರೂಪ್ 3 ಕಾರ್ಮಿಕ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಲಾದ ವಿದ್ಯಾರ್ಹತೆ ಪದವಿ ಡಿಪ್ಲೊಮಾದಲ್ಲಿ ಉತ್ತೀರ್ಣತೆಯನ್ನು ಹೊಂದಿರಬೇಕಾಗಿರುತ್ತದೆ. ಆದರೆ ನೇಮಕಾತಿಯನ್ನು ಬಯಸಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವ ಮೇಲ್ಕಂಡ ಅಭ್ಯರ್ಥಿಗಳಲ್ಲಿ ಈ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರುವ ಯಾವ ಅಭ್ಯರ್ಥಿಗಳು ಇರುವುದಿಲ್ಲ. ಆದರೂ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಸಲ್ಲಿಸಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಸೋನ್ಸೋ
ಮತ್ತು ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಸಾಮಾನ್ಯ ಸೋಂಕು ಮೀಸಲಾಗಿದೆ ಎದುರಾಗಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಸೇರಿದ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಟ್ರೇಡ್ ಟೆಸ್ಟ್ ನಡೆಸಿ ನಡತೆ ಮತ್ತು ಪೂರ್ವ ಚರಿತ್ರೆ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಪಡೆಯಲಾಗುತ್ತದೆ. ಆದರೆ ಅಭ್ಯರ್ಥಿಗಳ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸದೆ ಮೀಸಲಾತಿಯನ್ನು ಅನುಸರಿಸದೆ ಮಾಡಿರುವ ಈ ಕ್ರಮವನ್ನು
So you admit that the qualifications were relaxed. Who gave you the permission to again enhance the qualifications? You admit that. Therefore, you took a trade test. You have cheated him now.
No, but with regard to the second, that is, instead of giving to the SC candidate.
ST women, he becomes eligible. You appointed somebody else now. Because of your conduct, that person will lose a job.
With regard to the clarification, I will take discussion.
ಇದು ನೀವು ಡೆಲಿಬ್ರೇಟ್ ಆಗಿ ಮಾಡಿದ್ರೋ ಇಲ್ಲ ಅಲ್ಲ ನಿಮ್ಗೆ ಚೆನ್ನಾಗಿ ಗೊತ್ತಿತ್ತು ಈ ಕ್ವಾಲಿಫಿಕೇಶನ್ಸ್ ರಿಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಅಂತ. ಆದ್ರೂ ಸೆಕೆಂಡ್ ಟೈಮ್ ನೋಟಿಫಿಕೇಶನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ತೀರಾ? ಅಲ್ಲ ನೀವ್ ಏನಕ್ಕೆ ಮಾಡಿದ್ರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು. ಸೊ therefore you eliminated it after giving a promise that you don't have to apply afresh. For the fresh notification, will consider your application anta. You cheated him not once, twice.
Why they have come back from that?
We are not concerned with any reason. Once you relax the qualification, you are only re-notifying it. It is not a fresh publication. You are re-notifying it because there was some discrepancy in the reservation. You cannot thereafter manipulate other things and therefore thereby non-suited. The additional post create ಮಾಡಿ ಅಷ್ಟೇ. If he is otherwise eligible and also tell me as to what is the percentage that the person who has now been appointed and what is his percentage. An additional post create ಮಾಡಕ್ಕೆ ಹೇಳಿ ನಿಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವರು. Because he was selected and because of your mistake you had to re-notify. While re-notifying, you have cheated it. You have, by giving you an impression that you doesn't have to make a fresh application. He did not make a fresh application. Create a new post. Monday. ಮುಗಿಸಿ ಇದು ಹಂಗೆ ಹತ್ತಿರ ಮರ್ತು ಬಿಡುತ್ತೆ ಪೂರ್ತಿ. ಟ್ಯೂಸ್ಡೇ ಅವ್ರಿಗೆ ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ ಬಿಡಿ ಬೆಂಚ್. ಮಾಡ್ತೀನಿ. They'll give you a date. Who's for the respondent? 2/3. Orders गा ಕೊಡ್ತೀನಿ. Orders ಗೆ ಕೊಡ್ತಾರೆ ಡೇಟ್.
Like okay, everyone around yes. Antirika Sarika photo. Speaker.
Good.
ನೀವು ಸಂಜೆ ಗೌಡ್ರು ಬಂದಾನೆ. ಸರ್ what up sir? Shetty sir. Shetty sir. Matter ತೋಳಂಗಿಲ್ಲ ಸರ್ ಇವತ್ತ
What up, sir?
ಸರ್ ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ.
ಹೋದ್ರಿ ಅವರು.
I don't need a synopsis. ಅದು ಹೇಳಿ ಸುಮ್ಮನೆ ನನಗೋಸ್ಕರ. ಯಾವುದು? ನೀವು ಯಾರಿಗೆ? Anand submits that he's entering up. ಹಾಕಿದ್ದೀರಾ? Often to show the name of Anand. Really strong. Who has to file objections? Rectification. Week's time is going to be needed. You attended.
Matters. Number 1, SL Matti.
Yes, sir. My lord, I appear on behalf of the respondent state, my lord. My lord, on the last occasion, I made a submission that if positive directions would be issued for the initiation of acquisition proceedings is concerned. My lord, as per the government instructions, my lord, since the corporation has to send the proposal with regarding to relevant documents for initiation of acquisition proceedings, and they have assured that they will agree for the approval. But as on today, my lord, the corporation has not sent any proposal along with necessary documents for acquisition proceedings. Gadag Betgeri respond.
Hello, my lord.
Proposal ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾರೆ.
No, my lord, we have requested the government to give the preliminary permission to my lord proceed with the acquisition. My lord, they have given permission, my lord, we will proceed with the my lord further, my lord, in the matter, my lord. Last occasion when we have sought for that, my lord, they have refused to give the permission. First you took the permission, then you have to, my lord, go with the further, my lord. That was the, my lord, procedure they are following, my lord. Therefore, my lord, we have requested the government to, my lord, give the permission for, my lord, 50 acres. My lord, moreover, my last occasion, my lord, given, my lord, 21 acres, my lord, under the scheme, my lord, the farmer has come forward to, my lord, give the, my lord, his land for 21 acres. We are proceeding with that, my lord, 21 acres, my lord, ಅದರಲ್ಲಿ ಡೆವಲಪ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ. Now further steps we are taking further steps to, my lord, in respect of 21 acres.
ಒಟ್ಟು ಎಷ್ಟು ಎಕರೆ ಬೇಕಿರೋದು ನಿಮಗೆ?
50 acres.
They are seeking for 50 acres. They are seeking for 50 acres without placing any record to the government. Availability of land is concerned. On the last occasion, they made a submission along with one farmer has given proposal with regarding to 21 acres and odd. On that basis, my lord, the government as on today.
Government, my lord, is not making a fair submission. The procedure is, my lord, preliminary, my lord, we have requested to, my lord, but go, my lord, for acquisition. Preliminary, they have to give permission. Thereafter, my lord, we will collect the document and along with, my lord, project, we will submit the, my lord, project, my lord, before the government, my lord.
Who is your commissioner?
My lord.
Let him appear before the court and file an affidavit in this regard. You cannot keep on doing this.
Last occasion, my lord, that was the, my lord.
Let him be present. Let him be present on the next date. Let him file an affidavit.
My lord, in 21 acres, my lord, we are proceeding with the, my lord, project, my lord, in respect of 21 acres.
Let him come before the court, file an affidavit in that regard, and also state before the court as to whether he is seeking for permission for the remaining 29 acres.
Please, my lord, please, my lord, please.
Then AGA submits that
SCGP
submits that if the authority were to seek for permission to initiate acquisition proceedings, the state is prepared to consider the same favorably, but no such proposal has been submitted. Not counsel appearing for the authority, however, contends that preliminary permission was sought for and the same was refused by the state. He also states that a farmer has come forward to part with 21 acres of land, and the authority proposes to proceed with the scheme in the said 21 acres. In my view, it would be appropriate for the Commissioner of the Urban Development Authority to be personally present before the court and also file an affidavit as to what is the extent of land that is required for forming the layout and distributing sites so as to satisfy the claim of the petitioners. The affidavit shall also state the approval that has been granted, that has been obtained in the matter of purchasing 21 acres from the farmer directly. Released on
Commissioner of Gadag Betagiri Urban Development anta.
Second respondent tane.
How second? The Lordship directed the Commissioner of Urban Development Authority anta for that reason.
Second respondent.
Please.
1st December.
Please, sir. Please,
mobilize.
Your Lordships, I appear for petitioner in both the matters, Your Lordships. Your Lordships, both the matters are covered by Your Lordship's judgment, Your Lordships. We bow down to the judgment passed by Your Lordship. Your Lordships, may I make a request, Your Lordships, since Your Lordships have already laid down the law, the same has to be given implementation within a period of 3 months, Your Lordship.
That's what
no,
I
Your Lordship. Statutory period is not stated in the judgment, Your Lordships.
Yeah, judgment. I'll allocate it, then pass orders.
Please, Your Lordships. Only with respect to petitioners, kindly some statutory period may be stated, Your Lordships. The first matter has to be disposed of. Second matter has to be partly allowed, Your Lordship, because the notification circular which Your Lordships have set aside, I have challenged in the second matter that is under challenge.
What we have challenged
Your point? Again, Mandal challenge.
My lord, the matters are covered as far as serial number 2 is concerned, wherein 2016 impugned circulars are already set aside.
Even I have also challenged. So the matter has to be partly allowed, and the first matter can be disposed of, Your Lordships. Your Lordships have set aside the circular dated 21/3/2016.
As well as 2019. Both circulars have, my lords, are pleased to set aside.
19, I have not placed any reliance. Only 16 is my reliance. In the second matter.
The board is directed to implement the order within a period of 3 months on the date of receipt of a copy of this order.
May I request, my lord? One request. Since it should be all over Karnataka, my lord, because the regulations are only one, may I request some more time, because both HESCOM, JESCOM, 7 corporations are to redo the whole thing. If only 3 months, may I request? Again, it would be have to apply for extension.
No, regulations are already there. They are only going to do as per regulations. That's all.
May I complete, my lord? May I complete?
Make an application, I'll grant it. Once I say 6 months, it become 1 year.
No, may I request at least 5 months?
Please.
At least, I remember, because we have to redo all the circles. If it was a division, I would have bound on to that time limit. A small indulgence, my lord.
I will grant you definitely extension. But if I make it 6 months, you will go slow.
Please.
So
I'm not asking for 6 months, my lord. 5 months. 5 months.
Only 3 months. I'll grant an extension. Don't worry.
4 months ಮಾಡಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಜೆಸ್ಕಾಮ್ ಕೂಡ ಮಾಡಬೇಕು, ಎಸ್ಕಾಮ್ ಮಾಡಬೇಕು, ಎಲ್ಲಾನು ಮಾಡಿ 4 months ಆದ್ರೂ ಕೊಡಿ ಸ್ವಾಮಿ.
4 months.
My IA is taken as not pressed, Your Lordships. In the second matter, I have filed IA number 1 of 2023. That may be taken as not pressed, Your Lordships.
Yavadu?
IA number 2023 to D-Link, I had filed my application, Your Lordships. So,
It would be unnecessary to consider the interlocutory applications that are pending. Vakala Srimadilva ನೀವು?
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ, but one variation. I'll correct it, Your Lordships. Meanwhile, within weeks. I apologize. Your Lordship may kindly grant me time. I'll comply it, Your Lordships.
Much obliged. Permission to leave, Malad.
Much obliged.
Ross, I beg to appear for the respondent KDP, please, my lord. My lords, I'm under instructions, my lord, that we may not be, my lords, because it is going to be a precedent, and all others, my lord, many other people are similarly situated. My lords may.
My lord, your lordships that directed me to produce one judgment, my lord, of your lordships, my lord, under the KADB Act, the new act, my lord.
Please, obliged.
Please.
Ross, I apologize, my last date of hearing was not there, my lord. I deeply apologize, my lord.
All right.
I'm grateful.
Number 1, please. Ambedkar.
Unmute ಮಾಡ್ಕೊಳ್ಳಿ. Unmute yourself. You are muted.
Sorry, Your Lordship, sir. Your Lordship, a senior is on the leg in another court. Will seek a short accommodation. I'm appearing for the appellants.
Number 2.
Obliged.
Lord, I am for the petitioner, my lord.
Yes.
Last occasion they have sought file objection, my lord.
I granted you time on. He's without a job, isn't it?
Yes.
Pune.
Yes.
That's why I granted you. He's asking for an interim order. Also, grant him an interim order.
Yes.
Realist.
Please. Date.
1st December.
Obliged.
Number 1, passed over matters. Bill number 43.
Permission ಕೊಟ್ಟಿದ್ದೀರಾ? ಫುಟೋಟ್ ಯಾವತ್ತು ಹಾಕಿದವರು? ವೆಲ್ 10 ಆದ್ಮೇಲೆ 1 ತಿಂಗಳ ಮೇಲೆ ಕೊಟ್ಟಿದ್ರು ಅಪ್ಲಿಕೇಶನ್.
Next page.
ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಗೆ? ನಿಮ್ಗೆ ಎಷ್ಟು ದಿನ ಬೇಕು?
ಮುಂದೆ age ಮತ್ತೆ term tenure was not fixed. We have raised an objection in 2020. ಅದನ್ನ ಇದು ಮಾಡಿದ್ದೆ ಅಂತ ಹೇಳಿ
ಇನ್ನೊಂದ್ಸಲ ಹೇಳಿ.
tenure fix ಮಾಡಿಲ್ಲ. tenure ಇಲ್ಲ ರಿಜಿಸ್ಟರ್ಡ್ fix ಮಾಡಿಲ್ಲ ಅಂತೀನಿ. That was question before this court. Proposal was there earlier, there was a bylaw. Proposal was there on bylaw. That has to be modified ಅಂತ we have said a proposal. Proposal accept ಮಾಡಿ ನಿನ್ನೆ they have the decision was taken. It was sent.
Now that is cured. Tenure ಹೇಳಿದಾರಾ?
ಇಂದ ಕಳಿಸಿದ್ರೆ ಇನ್ನೂ accept ಆಗಿಲ್ಲ. ನಿನ್ನೆ ತಗೊಂಡಿದ್ದಾರೆ. ಹೈದರಾಬಾದ್
ಯಾವಾಗ ಮುಗಿಸ್ತೀರಾ ಇದನ್ನ ನಿಮ್ಮ ಅಪ್ರೂವಲ್?
3 days ಕಾಲ.
ನೀವು
ನಾವು ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು within 3 months ಇಲ್ಲ.
ಹೋದ್ಸಲ ಡಿಸ್ಪೋಸ್ ಮಾಡಂಗ್ ಆಗಿರೋದು
15 days ಕಾಲ.
15 days ಬೇಡ, 10 days ಕೊಡ್ತೀನಿ ಮುಗಿಸಿ ಅಷ್ಟೇ. ಏನೋ ಮಾಡಿ ನೀವು ಯು ಆರ್ ಕ್ರಿಯೇಟಿಂಗ್ ದಿಸ್ ಲಿಟಿಗೇಷನ್ ಅನ್ನೆಸೆಸರಿಲಿ. AGA submits that the request of the nursing council for grant of administrative approval is under consideration, and in all probability a decision will be taken within a period of 15 days. Later the said submission relist on. Madam, I have already expressed my mind. None of you are applicants. No, I am prepared to decide this writ petition and hold that you do not have the locus standi to challenge an in-charge arrangement. There was no application, there is no contest. Madi. Madi. I didn't want to go into that. I thought your ultimate remedy is to be a regular registrar, not an in-charge registrar. Where is Sumana? ನಿಮ್ಮಿಷ್ಟ. ಅವ್ರಿಲ್ಲ ಅಷ್ಟೇ, ಸುಮನ ಬಾಲಿಗ ಇಲ್ಲ. ಅವ್ರಿಗೇನು ಮೈ ಹುಷಾರಿಲ್ಲ ಅಂತ ಏನು ಹೇಳುದು ಬೆಳಗ್ಗೆ. ಅವ್ ತಿರ್ಗಾ ಬಂದ್ ಏನ್ ಹೇಳಕ್ ಹೋಗ್ಬೇಡಿ. ಏನಾರು ಫರ್ದರ್ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾ? ಅಫಿಡವಿಟ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಹೇಳ್ಬೇಕಾ? ಇಲ್ಲ ಕಸ್ರಿ ಏನ್ ಸುಖ ಇಲ್ಲ, ಅಲ್ಟಿಮೇಟ್ಲಿ ಕೆಲಸ ಆಗ್ಬೇಕು ತಾನೆ. ಅದೇ ಸೇಮ್ 45, 46. 47. You pass it over. Burley Insurance Company.
Number 47, Shiva Mahesh.
ಹೇಳಿದ್ರ ಬೇರೆಯವ್ರು ಬರಲ್ಲ. Next Friday. Inform him next Friday and take it up. Where is he again? We pass it over again and let him come. ಅವ್ರೇನಾರು ಹೇಳಂಗೆ ಹೇಳ್ಬಿಡ್ಲಿ ಅಂತ ಅಷ್ಟೇ. But if you argue and if he does not reply, if you get him and take it up. ಸಿಕ್ಕಿದ್ರಾ? Monday orders list. ಏನಂತ ಅಲ್ಲ ಅವತ್ತು ಬಿ ಸಿ ಕೇಳಿದ್ದೇನೆ, ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ರೆ ಎಲ್ಲರಿಗೂ ತೊಂದರೆ ಆಗತ್ತೆ, ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಯೋಚನೆ ಮಾಡಿ ಹೇಳಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ನಾನು ಸಜೆಸ್ಟ್ ಮಾಡ್ತೇನೆ, ಆಮೇಲೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು
ಇಂಟ್ರಿಮ್ ಡೈರೆಕ್ಷನ್ ಅಂದ್ರೆ ತಿರ್ಗಾ ಪಿಟಿಷನ್ ಇಟ್ಕೊಂಡಿರ್ಬೇಕಾ? ಗಿವ್ ಮಿ ದ ಫ್ಯಾಕ್ಟ್ಸ್.
On 19/12/2002, there also he had got a allotment of director. So discharging the duties completely till January 20. Even I wish to request my lord. Page number 24. Parent nation of the Karnataka limited to the tax. On December 2019.
Next year.
The page number 24. So even in December, probably on January 30th, they asked me not to come to the office. And the reason given in the application statement that Saraguru Gram Panchayat has been converted into Saraguru Jilla Panchayat, hence there were not hours. Quite of working for nearly 22 years. He has been out of the report for survey and asked him not to come to the office. They have paid salary up to September 19, and from October 19, no salary has been paid. So he is the main dependent on the member of the family. And in there, nothing is taken.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲೇ ಗವರ್ಮೆಂಟ್? ಬನ್ನಿ. The prayer in this writ petition is for washing off next year G and for mandamus to the third respondent to pay the petitioner the salary for 17 months commencing from January 18. A prayer is also made to continue the service of the petitioner in the office of the third or fourth respondent and pay him the back wages with continuity of service and also to regularize his services. The following facts are not in dispute. The petitioner was appointed as a temporary bill collector with effect from 1/8/1997. This appointment was made on the basis of a unanimous resolution passed by the Sargur Gram Panchayat on 30th of July 1997. The petitioner was thereafter transferred alva to HD Dev was deputed to the HD Kote Town Panchayat on 6/12/2012, and he also reported for duty there on 7/12/2012. It is admitted by the state in its counter that the petitioner continued to work as a bill collector till September 2019. They have admitted. The petitioner, however, contends that he has been working till December 2019 and he was stopped from discharging his duties on the ground that his appointment was irregular. Appointment was irregular in the sense that the power of appointing a person to the town panchayat was with the municipal council and not on the basis of a resolution passed by the Gram Panchayat. The above indicated facts establish that the petitioner has been working from 1997 till 2019. That is for a period of 26 years. Though he was stated to have been appointed temporarily as a bill collector. It is also not in dispute that the petitioner has been on deputation to the HD Kote Town Panchayat since 2012 and he has worked in the town panchayat for a period of 9 years. In the light of the fact that the petitioner has been working for the past, has worked for more than 23 years. 23 years, 24 years as a bill collector. It is obvious that the respondents could not have contended that he was ineligible to continue on the ground that the appointment ought to have been made by the municipal council and not by the panchayat. The respondents having extracted work for more than 26 years would be stopped from contending that the appointment itself was irregular and the petitioner would not be entitled to continue as a bill collector. In that view of the matter, the direction is issued to the respondents to reinstate the petitioner forthwith and permit him to continue working as a bill collector. So, since the petitioner has been working for more than 26 years, a further direction is also issued to consider his case for regularization and pass appropriate orders within a period of 2 months from the date of receipt of a copy of this order. The petitioner shall also be entitled for the salary for the 17 months. For 2 more months. So also be paid to pay the salary for the months of October, November, and December, during which the petitioner had worked as a bill collector. Just first ಕೆಲಸ ತಗೊಳ್ಳಿ ನೀವು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇಟ್ಕೊಂಡಿರ್ತೀನಿ ತಿರ್ಗಾ ನೀವೇನ್ ಮಾಡ್ತೀರಾ ನೋಡ್ತೀನಿ ಆಮೇಲೆ ಡಿಸೈಡ್ ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಡ್ಲಾ ಬೇಡವಾ ಅಲ್ಲ ಆಮೇಲೆ ನೀವು ತಿರ್ಗಾ ರಿಜೆಕ್ಟ್ ಮಾಡ್ರೋ ರೆಗ್ಯುಲರೈಸೇಷನ್ that determination cannot be made at ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಇದನ್ನು that we made, it is clear that the prevention of the act of respondents in preventing the petitioner from discharging his duties from January would be illegal. The direction is therefore issued to reinstate the petitioner forthwith. The petitioner would also be entitled for the salary for the period of October, November, and December 2019. ಅಲ್ಲ ನೀವೇ ಸೆಪ್ಟೆಂಬರ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದಿರ, ಡಿಸೆಂಬರ್ ಕೆಲಸ ಮಾಡಿದಾರಲ್ಲ ಅವ್ರ ಪ್ರಕಾರ. ಅಲ್ಲ ಅವ್ರು ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಲ್ಲ ಕಾಸು ರೆಮಿಟ್ ಮಾಡಿದಕ್ಕೆ. The having regard to the fact that the petitioner has been working for 26 years, the respondent shall also consider his case for regularization and report the same to this court. Relist on for further consideration. Now, first ಅವ್ರು reinstate ಮಾಡಿ ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ. ಆಮೇಲೆ ಎಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ ಕೊಡ್ಲಿ? ಅಲ್ಲ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಬಗ್ಗೆ ಎರಡು ಮಾಡಿ ಒಟ್ಟಿಗೆ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ. ಫಸ್ಟ್ ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿ ಫೋರ್ತ್ ವಿತ್. ರೆಗ್ಯುಲೇಷನ್ ಬಗ್ಗೆ ನಮ್ಗೆ ಆಫ್ಟರ್ 4 weeks ಒಂದು ಹೇಳಿ. ಮಾಡಲ್ಲ ಅಷ್ಟೇ. ಆಮೇಲೆ ಅವ್ನು ಸಾಯವರೆಗೂ ಅನ್ನೋದೇ ಡೈಲಿ ವೇಜ್. ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಬಿಡಿ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ. ನೀವು ಅಪೀಲರ್ ಹಾಕೋಬಹುದು ಅವಾಗ, ಇದ್ರೆ ಸುಮ್ಮನೆ ಅಲ್ವಾ? Since it is not in dispute that the petitioner has been working for the past 26 years, it is obvious that the service of the petitioner would have to be regularized. Consequently, a direction is issued to the respondents to regularize the service of the petitioner as a bill collector. It may be pertinent to state here that the petitioner is on the verge of superannuation, in the sense that he attains age of superannuation in the month of April 2024. In the light of this particular fact, it would be imperative that that the respondents regularize the service of the petitioner forthwith. The petition is needless to state that the petition will be entitled for the benefit of continuity of service and other consequent benefits. He shall however not be entitled to any monetary benefits pursuant to the order of regularization. ಏನ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಇನ್ನೇನಿಲ್ಲ.
Number 2, number 1.
Let him start. Yes. $200? Yes. What was he working as?
He was working as officer.
Assistant manager.
As assistant manager in the last year in the exceptional last track. In the previous manager.
What was the charge against him?
That's what happened was. Charge as a track. What happened was on October 19th, what actually happened was on 21st February 1995.
The gunny bags outside the bank.
Gunny bags outside the branch. Then what happened? Actually, they had 4 of them were outside the branch. One was just entering the branch. Branch had nothing to do with that. Then also the cash was apprehended. Thereafter, the Commissioner of Customs issued a show cause notice to the bank. Then what the bank replied, starting from the opening of accounts until handling of cash, entire gamut of transactions, bank replied that there is no fault committed by any officer. Every customer has been personally, physically present by the account. All of them have been properly introduced. And there was no law at that point of time about acceptance of cash in huge quantities. Except more 1 rupee, 2 rupees, you cannot make it. That's not a legal tender, and therefore they have been properly accepted. Then there was an investigation also ordered by the bank. On the basis of that investigation report, this final picture was submitted by the bank to the enforcement director. Then bank reply was rejected, and a penalty was imposed on the bank to the extent of 50 lakhs. 50 on the bank and 4 or 5 on the top. Then the bank also started simultaneously accepting the proceedings against all of them. Though all of them were involved in the same transaction, they were independent enquiries for the experience. In the department inquiry, what happened was I saw certain documents which were not made available.
Inquiry was conducted against how many officers?
Inquiry against 4 or 5 officers were there, but against each of them, separate inquiries were held. Instead of holding a joint inquiry against all the officers. Varying penalties were imposed on different officers, starting from censure, then stoppage of 2 implement, etc. In my case, the penalty of dismissal from service was imposed. By doing so, 2 serious infirmities in the inquiry.
Show me the charge first.
The
exact charge.
Is at the page, but the draft memo is at page 63 annexure C. In that, only one aspect I find out before I read the charges. At page 64, last 3 lines. You will in the list of right cash paid from some of the parties who were favored by you as indicated above. This aspect has been held to be not true.
And let me see the first charge.
First is this one, that during the period between 10/11/93 and 25 to 95, you were working as a manager at a normal finance bank complex. And that was functioning in your function as well. You permitted supervised opening conduct of operations in 6 current accounts open in bank. 21. 11 current accounts open in bank in period from 21. 30 current accounts open in bank in period between 1993 to 1995. Without following the late note guidelines concerning opening of accounts allowing operations in the account communicated to the bank by head office through manual of instruction for
circular issued from time to time. Without taking reasonable response, taking reasonable response, modified to the introducer and the prospective customer, without making reasonable response, filling into several flows of rupees transacted to the account by the parties referred as referred in the work form. Without making reasonable response, purchasing gas or food or and in furtherance of the above, you permitted disposing of such other instruments. The part which amounts to parties purpose in aspect 1.3 without setting the benefits of the transaction for the party. The causing to the other debit balance in the current account without ensuring a use of the fund. In further, if you take the opening features to Belani and unscrupulous persons on the road to carry on all monthly Belani transactions. It is reported that on 21 to 95, there had been conducted a raid by the Director of Revenue Bombay at the branch and believed that cash moved into rupees 100.78 for reported from certain parties were come to remit the same current account and thereafter balance in the current year from payment of certain officers or parents of most parties of the direction of the TRA account. That continues on the next page. Those last 3 lines are not moved because of that everything is not moved.
The first charge is proved, permitted opening of fixtures account.
Open and done that
That is proved.
all other charges the inquiry of the roads are proved. But it is wholly contrary to the reply given by the bank to the enforcement directorate.
So there are basically 2 charges and there are sub-charges in that.
In that sub-charges, the inquiry officer what he does, he frames 13 issues. Well, he holds against the 13th issue regarding the acceptance of illegal gratification. He says it is not true. There is no evidence. In fact, with respect of all these charges, you may also kindly turn to page 109. This is the reply furnished by the bank.
That is your defense. Basically, that is your defense.
When I mark this document to the inquiry along with my defense statement, the inquiry officer refuses to rely on this document. First, I seek this document as a defense document required by me. This document, then I produce it along with my defense statement after the control of the management. A copy of it is served on the presenting officer also in the inquiry. No objection is raised by anybody at the time of my purchasing this document. Inquiry officer says, Marotti does not rely on this document because it is not properly introduced.
You are properly introduced on that?
Oh, here that proper, that's the reason he gives. I'll submit notes of when I introduced it. This is 12/8/1996 is my.
In this reply, they say that there is no fault on the part of the officials.
There is no fault even in the matter of opening of accounts. The customers have personally come to the bank because the allegation was paid on me. In this, they say that every proceeding, every banking procedure has been followed.
When was the date of the charge sheet?
Charge sheet is dated, charge sheet is dated 30/10/1995.
And this reply is dated,
This reply of the bank to the enforcement directorate is dated 20/11/1995.
2011,
2011.
afterwards.
Afterwards,
Yes.
but the page 247, the inquiry officer declines to consider this document.
Where at 247?
Page 247. Is a middle of the page about the first paragraph. 5 lines, last 6 lines. I also observed from the enclosure to the written statement of business dated Colgate 1996, submitted by the CS who is charged of the employee, that this document is not properly introduced by giving reasonable opportunity to the presenting officer to verify the denial of the same.
Yes. How does the appellate authority deal with this?
Appellate authority does not even perpetrate, and what he says is that inquiry has been held properly at page 276 which the order of the appellate authority.
Page?
Page 276. In fact, this ground was specifically raised by me in my appeal.
Two 76 is the appeal order.
Yes, and then of the fair. One is no reference to the not marking of the company. I can, as the applicant does not create any consideration. I do not find any reason to retain any business of the bank. This is the Where one of the banks has been garnished. That is in the other authority. And ultimately, the current authority, second has reversed the order of guarantee for the customs commissioner and the examiner to cash.
Your fundamental difference is that the bank itself says nothing wrong in.
Bank itself contended, and that has been accepted also by the appellate authority. And this part of my different statement, of the bank purposely proceeds says. That's page 99.
And the reply was given after the charge sheet was issued. Charge sheet was issued in the month of October 95. Reply is given in the month of November 95.
Yes, November 95. This reply is dated 20th November 95. Even before issuance of the charge sheet, they served on me a memo on 8th August 95, Section A.
What is the date of the charge sheet you said?
Charge sheet date is perhaps the date of the charge sheet is 13/10/1995. That is
Reply is dated?
My reply is dated
Reply of the bank.
Statement.
Reply of the bank to.
Bank, that is 20th November 1995. Page 3 of the sources I mentioned the date.
Yes.
No, what happened? Some document was delayed to me. Software service charge sheet. The first inquiry sitting was held on the page 79. On 15/4/1996.
Yes.
On that time about.
When was this reply marked? When was this reply?
Reply was part of my defense statement filed before the inquiry officer. During the inquiry as of 12/8/96.
Referred to this 15/4/96 for what?
12/8/96 for the J bar 126, you are allowed to take page 126. That is the first sitting of the inquiry. After the preliminary sittings of delaying the charges and ordering production of documents. But the regular inquiry commenced on 12/8/96. On that time, also at page 156, I state this one. Before the commencement of the inquiry, I asked the prosecutor of the inquiry, Mr. Padia, that whether on verification of management documents provided to him, he pleads guilty of the charges indicated in the opposite charge sheet, or he has defense to make. As the CSOE does not submit charges, I have continued the inquiry proceedings. Then at this stage, I advise the presence of the produce. Then another is produced. It was not regarding my statement. On that day, before the inquiry officer, I give this 12/8/96 defense statement along with the reply of the bank, that is at page 99. No, not page 99, at page 102. In his report notes, he accepts that he has received this defense statement on 12/8/96 and also the reply of the bank. But he says it is not properly introduced.
This was marked as what exhibit?
It is not, he is not marked Olympic. Yes. He did not mark it, he reserved it. But luckily for me, he refers to it in his inquiry report.
Yes.
Inquiry report notes it commences at page 151.
At page 247, he says he's not taking cognizance of that.
Yes, Central Party Committee, he said, I will not take cognizance of it.
Yes.
As a matter of fact, I have asked for correction of these documents to start on next time. My lord will get it. On the first day of the inquiry of the order that I shall furnish to the suggestion of the bank list of documents that I require for my defense.
Who gave that reply to the bank?
That is not signed by the head of the bank, assistant general manager.
He was examined as a witness here.
No, he was not examined as witness.
Did you summon him? No.
No, sir, it's not because what happened for this. He was also facing charge. And then I could, because of the bank, I have made available at the first stage of the inquiry itself, my defense statement and this letter.
No, but if that reply is given by a person who is also accused of.
It is signed by his, even on behalf of the bank, signed both by the advocate of the bank and also the branch head.
Was he accused of any wrongdoing, the branch head?
The charge was against the bank by the enforcement directorate and on behalf of the bank and its officers. So all of them were accused.
No, if the head office or somebody superior to the branch had endorsed that reply as the reply of the bank.
That is it. That is the stand of the bank throughout the proceedings.
But
it is a defense statement. It is a reply given by the signed by the bank's advocate and the head of the branch on behalf of the bank. In fact,
but he was also an accused in this.
He along with the bank itself was an accused.
No, in the inquiry proceedings.
In the inquiry proceedings, he was not charged along with me.
No, but he was charged.
Separately, they say they are charged.
And what is the
penalty, censure or something like that, or directed to be cautious in future. In fact, I have filed an IR for the petition. To summon the records of inquiry for penalty imposed on those citizens and officers. In my work, kindly read the reply. There is not the reply of the right say.
No, I was prepared to accept this reply. I was prepared to accept this reply as a good defense of yours. But if the person who signed the.
Signed on behalf of the bank.
Maybe so, but is there anything to show that the head office approved it?
Yes, no, in fact, the foreign under syndicate bank marginal point authorized signatory. It is signed by the deputy general manager.
Where is the reply? Next year.
Connection of page 109 is reply of the bank commencement and ends at page 125. This is basically reply of the bank, of the advocate of the bank, also attested by the bank. I have been retained to act appear freedom process syndicate and current plan. Here is after for the notices to respect the notice.
No, the branch was at Bombay. Replace given by a lawyer at Bangalore.
Well, there is GP Kumar. He represents the bank for. Bank does not say ownership was not not on behalf of the bank. They don't say ownership, but local going to say that it was individual aliens reply. On the other hand, most of page 247, what he says is the employer, this document is not properly encrypted. That's not. In fact, when I saw this document as required for my defense, what the bank says, the employer officer does not got the order on my request.
There are only 2 witnesses examined on their behalf.
The only investigating officer, then the manager look to this other second time manager was examined as MW2. That is one of one which will go with us. Another second line manager is different.
And do they admit the contents of this report, this reply?
This reply they have relied on this is the exact difference before the enforcement director.
Maybe so. No. In this inquiry, do they admit of this?
This inquiry, what happened is this. I wanted this document for my defense. That was not made available to me on this ground. That the documents, in fact, classification also is district question, but my lord's hospital in fact. Where is the order of the inquiry officer on request for document? At that stage, the
So according to no order was passed.
no order, page 141. That is after the commencement. Though I sent the request for documents on 10/9/96. Then even after concluded management's evidence, when no order had been passed by the inquiry officer, I was called upon to state my defense at page 141. I make a representation to the inquiry officer. Before submitting the defense, inquiry is submitted, despite repeated different management of not submitted the following documents, which according to them were very weight for disputing charges. Then
Have you referred to the reply here or no?
I am very because by then I had already obtained a copy and I have made it bank given to the bank, given to the inquiry.
Okay.
Because on 4896 I have got.
Yes. This was not furnished to you according to you.
It was not furnished.
But he has passed an order saying that he doesn't allow them at page 142. PO has claimed privilege as they are classified and confidential documents. In view of the confidential nature, I am not allowing the above documents. However, he has considered the documents mentioned at 4 to 7 are not
Available, not maintained, not present. According to the regulations, some document has to be filed in privileged document. The officer in whose custody that document is, he has to claim privilege. It cannot be, privilege cannot be claimed by the presenting officer. And one document is that they are confidential documents. And more, sir, as on the 70s, more Supreme Court has said, no document can be denied by a charged employee on the ground that it is a confidential document.
Okay.
And then I am not allowing the above document. The respect of first three items, presenting officer has been privileged as they are classified and confidential documents. The Lord kindly have looked at that the inquiry regulations which speak of how the privilege has to be defined. ಅದು ಒಂದು ಹಾಕಿರಲಿಲ್ಲ 16 September regulation.
Syndicate Bank officer employee.
Yes, sir. The basic is the procedure regulation procedure for imposing agent plan.
Yes.
It will not kindly take the regulation 8 at page 7 that speaks of pleading guilty or not guilty. There are some others. If the employee does not plead guilty, what the employee officer has to do is sub-regulation 10 at page 8.
Yes.
They are not the inquiring authority. Done. When the officer employee does not admit all or any of the articles of statute money, the said officer employee is published to the employee. A list of documents by which and a list of article charges are proposed to be proved. The inquiring authority shall also result an order that the officer employee made for the purpose of preparing defense. Inspect within 5 days of the order or within such further time not exceeding 5 days as the inquiring authority may allow the document. Submit the list of documents and witnesses that he wants for the inquiry. We subscribe copies of statements of witnesses to any recorded earlier. Inquiry authority shall furnish such copies not later than 3 days before the commencement of the examination. Even notice within 10 days of the order or within such further time not exceeding 10 days as the inquiry authority may allow, but the discovery or production of documents referred to in item 2, then the documents are need for taken. The next one, sub-regulation 11. The inquiring authority shall undertake the notice for the discovery or production of the document. Forward the same or copies thereof to the authority in whose custody or possession the documents are kept, with the requisition for the production of the documents on such date as will be specified. On the receipt of the requisition and the sub-regulation 11, the authority having the custody of provisional requisition document shall arrange to produce the same before the inquiring authority in the date, place, and time specified therein, provided that the authority having the custody or provision of requisition documents may claim privilege if the production of such documents will be against the public interest or the interest of the bank. In that case, it shall inform the inquiring authority accordingly. Here now, I request for I submit my request for documents. This was that my request for documents is at page 99.
He is duty bound to secure the document, and the authority which has the custody can claim privilege.
He can only claim privilege on the ground that its disclosure will be adverse to the interest of the bank or public interest.
The presiding officer can't claim privilege.
Presenting officer claims privilege here, that will by what say. Presenting officer claiming privilege laws. It is totally contrary to natural justice for this reason. Because prosecutors knows the contents of it. That is the presenting officer. I am denied knowledge of that on the ground that it is privilege. That is the reason why the regulations insist. Privilege should be claimed with authority and custody. It should be a level playing field in the inquiry. There is no order is passed on that. In fact, the inquiry officer does not even forward the requisition to the authority in whose custody the documents are. Because the inquiry officer had directed, I should publish a copy of the requisition for documents to the presenting officer. Also, I had sent it to him also. Then in the inquiry, at page 126,
yes.
at page 126, first witness, N.R. Kamat is examined. He is the person who had conducted investigation in the wake of raid of enforcement directorate and submitted a report. And that investigation officer is the star witness in the inquiry.
Is MW1, huh?
MW1.
The report that he had prepared was also marked? No.
No, it was not made available to me. Again, time is delay. In spite of me asking, further.
Yes.
Here now, he commences with witness evidence like this. I am so and so working in vigilance unit, regional inspector at Mumbai since March 94. And I instructed to head office vigilance cell. I conducted investigation of .5 line during April 95 and May 95. In respect of opening of certain suspected fixtures, current accounts, and carrying out unusual transactions taken by certain parties outside non-confined area. During the course of the investigation, I found certain irregularities on the part of Exarchia, the then sub-manager of Karimam Pakistan. I identified the documents produced by the figure number 1 in the list of documents now shown to me. These documents they are all voters on the paper of the grant. Then on he said at page 129.
Yes.
Now I would like to summarize the irregularities observed by me during investigation. He says what are the investigation and then he refers to. Finally, the raid conducted by DRI that directed to the stop etc. Then
he accepts that show cause notice was received.
Yes, and then he also said, I have submitted the report. And that report is not made available to me, even though I have got it at the first instance itself.
Where does he talk about the report?
This one, during the investigation, I observed them. Then he talks about the report. At page 131. In answer to the question number 10. I am disposing on the basis of my investigation findings and feel that the spirit of the circular guidelines should be followed scrupulously. Page 131. In fact, there is no question number 10. In a busy branch like Narayan finds, it is possible for the and the bank admits there having been an investigation for. Even in the first notice that it issues to me, prior to the charge sheet, as a prelude to the charge sheet, at page 43, annexure A, in the first notice they issued to me. It starts with the sentence, it is reported as under. And last sentence of this memo here, this letter, it reads, all the documents are in the custody of NR Council. That is at page 48. After stating these letters have your recommendations within 15 days of the itself, the document records relating to transactions are in the custody of the NR Council, gifted with the manager, RA Council. Yes. Yes. Then thereafter, after the two witnesses, that is MW2 is at page 135, Lohita, he is cross-examined. Who is he? He is another manager administration in the same rank. Then I examined the this notes at page 141. I again seek those documents, copy of the special inspection report that is not common for. So this is privilege, isn't it? This is and then two other inspections, concurrent audit before I have seen of available company. That is a branch which is subject to concurrent audit. Every day transactions are audited and report quite very concurrent audit. The third thing I require, I ask is, copies of the regular inspection report for the year 94-95. It is not available. Our more privilege inspection reports, okay, I paid on the time. How they can be privileged? Therefore, there is one clause in the regulations which say after the conclusion of evidence in support of the charges, the inquiry officer, if I have not examined myself as a witness in my defense, shall formulate from the evidence the circumstances appearing against me in the evidence and put those circumstances to me to be explained. That is what sub-regulation 17 of regulation 6, which my lord would get at page 10 of the regulations I have provided. The inquiry authority may also be appointed.
Generally question.
Generally, question means on the circumstances appearing against it. It is comparable to our section 313 of the CH-16.
This has not been done.
This has, how he does it at page 142.
Yes.
He has done the on the face, he appears to have done everything, but he has not done anything. With your background and experience in the branch working, if you are any stage, speak will be off. This one, as CS has not appeared as witness, may generally examining in terms of regulation 617 of the CBS disciplinary affairs regulation by asking the following questions on the circumstances appearing in the evidence so far appeared in the FIR. Not a single circumstance appearing in the evidence is put to me.
Yes.
Then after that, I examined 3 witnesses in my defense. 2 witnesses. 2 witnesses in my defense. In my defense. The first witness is Sudhir Zaveri, one of the customers in whose accounts it was alleged that I have ordered more licenses at page 143.
Yes.
He clearly says in his evidence, that all the over clients were allowed to him by the then chief manager. He used to have all these discussions regarding the top-class customer of the brand. He says, all my banking needs I was discussing with chief manager of the brand, so the head of the brand. And he also names another officer as the person with whom he was discussing. And he says, all the more clients have been allowed by Mr. Subramaniam, chief manager of the brand. Then once cross-examination is conducted by the presenting officer, then he makes a suggestion at page 147.
Yes.
I put it to you that you used to approach SR Padiyar Satyanarayana Bank directly, knowing fully well that it was not empowered to sanction TODs, CDDs, and again with a view to gain undue financial accommodation, and thought it fit to close your account with the branch that the matter was taken up in the investigation officials. Do you agree? I never approached SR Padiyar Satyanarayana for any financial favors such as TODs, CDDs, and against it. I appreciate that you are possibly imposing this forum to cover up the irregularities first as committed.
But this gentleman has no knowledge about the transactions.
How can he have all these things? There is a question on how can he have whose powers are government and all. He says that in the even in that page 146 also. I was meeting Mr. Subramanian, chief manager of the branch. Then notes is a roadside business in iron and steel. And at Mr. Page 145, he says that is last 5 lakhs for that corrector. Before I sum up, I wish to state categorically that we were dealing directly with Mr. Subramanian, the then chief manager, and with no other officers of the branch. The credits of the penny that were enjoyed by me and another fine were due to benevolence of Mr. Subramanian and yes. Then second witness I examined.
So the thrust of your argument is regarding that reply and the fact that documents that you sought for were not produced.
Yes.
And the third argument is that you are not questioned under Regulation 617.
And another aspect is this one. Banks reply to this one. It was state, it is a consummate interest state.
That is your trump card.
One of the strong grounds. And they may not ask me a question whether they can feel that. I have produced as an extra few. I have produced as an extra few members because this order came of the second during the pendency of this petition.
Page?
Additional statement of fact to the document and 26(2).
Yavaga?
Next day, June, that was very long. 26 February 2001.
How don't you have a date? Date.
So it is filed members in the industry.
I got it.
On 1st March 2001.
Next year Q, alva?
Next year. First appellant was the bank, and it was represented by V.V. Kumar in the same matter. At page 5.
Page?
The first appellant is V.P. Naik, second appellant page 5, page 1 of the order.
Where is the?
Page Q.
Where is the
Advocate says
no, order regarding the bank's appeal?
this is the common order in all these appeals. Where the 7?
All of the appeals are allowed.
Ambala Sura and other people not the other notice to file reply and were heard.
This appeal was against the.
This appeal was against the order of the commissioner. Who my lord will find at the bottom of page 5 of that, at the first page of the. Para 7 there of the
Therefore, bank was exonerated.
Everyone of us, in fact, I was also one of the opponents there. I lot to get my name. Yes, sir, Padia and tell Bombay Mercantile Bank, there of Game Supermarket was the chief manager at that time. Nuclear secretary, then yes, sir, Padia.
More importantly for you, the appeal of the bank was allowed.
The bank was allowed.
Fair, ba?
That's all.
Tomorrow. I heard the matter, 97 matter. How can you ask for that? Tomorrow. You only have to give a reply, isn't it? Tuesday I have too many matters. Do it tomorrow. You are here for me. Madi, nade madi. On 670.
First, my inspection was allowed 50% factor. Then once in the appeal, the order was reversed, certain findings, and matter was reported. Against the order of demand of 17 in the effect the Supreme Court said, all contentions are open to judgment of the that is all.
I'll forget the whole thing. The second time this is happening. It should not take a long time for you. You should cooperate with me more than.
Number 3.
ರೆಡಿನಾ ನೀವು ತಾನೇ ಇದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರೆ ನೀವು Yes. 2011 में have they filed objections? What is their objection? Transfer material pending is.
The appointment by transfer is a scheme university was available to be that regulation provides for
Annexure F.
yes, one member engineer change of care to post of assistant engineer.
Read Annexure F.
Actually, this is not the hacker market here is the there also the people I can the scheme was a regulation 10A. First, the regulation 10A was initially was minimum for 7 years. Then there was subsequently 2010. That has been given.
No, this is not in your favor.
Yes, so that is my favor only. But they have even at this benefit, considering the word unamended regulation, not as per the amended regulation. 27/2010, plus the regulation 10 was amended. The qualification was 7 years, came to reduce to 3 years. There was
The prayer is insofar as relates to
retrospective was consideration. There would be promotion to the post of assistant engineer.
where do you get the 7 years and in this order?
That was regulation 10 year.
ಈ order ಏನು ಇಲ್ಲ.
Yeah, regulation 10 year annexure B 14 mechanism. Regulation 10 year. Usually it was 7 years now. Subsequently, it was amended on. Seven 2010. This amended law. Where it was that has been reduced to 3 years.
ಇಲ್ಲಾಗಿದೆ amendment. Where is it amended?
Page 16.
It says 7 years.
One by transfer of service. Inside is
It says 7 years.
Yes, sir. There are what? 10 page 21.
Page
page 21. 26/7/2010. Amendment is brought out 26/7/2010. Amended as last follow. Putting a minimum service of 3 years as.
But when were you appointed by transfer?
Because that is the order note, next year, yeah. 29 September 2010, subsequent to amendment. Subsequent to amendment. But they are considered like claim under the old regulation, not as per the new regulation. Very short point is involved first.
No, this is the requirement, isn't it?
Yes, sir.
So
I initially appointed Brod's as a junior engineer. They're like, I applied for qualification in year 1998, sir. Petitioner was appointed in the year 2003.
Okay.
They have considered that.
you became eligible for appointment only on completion of 7 years.
Yes, sir.
As per the then regulations.
Yes, sir. As per unamended regulation, sir. But before giving me.
So how can you be appointed retrospectively from 2003, from 2006?
They consider not like 2006.
Okay.
My initial appointment is 2003.
Suppose they do that. That means they're appointing retrospectively from 2006 when the amendment in the year 2006. In the year 2006, the regulation stated 7 years. They could not have appointed you. In order to be appointed as dust engineer by transfer, one of the eligibility is you should have been junior for 7 years.
They have the scheme applicable to them. The petitioner will have to have acquired PE degree in the year 1998, sir. But he is appointed as junior engineer on the basis of his diploma qualification. Thereafter, the petitioner made a representation considering his claim for regulation under the regulation. That has not been considered.
When did you make the application?
Because that application
was done only in 2010 after completion of 7 years. Because you could not have made the application earlier. No, you could not have made because they would not have been appointed. By virtue of this amendment, after the amendment, every junior engineer who had put in 3 years becomes eligible.
Yes, sir.
How does it help you? Can't be from 2006. Then you are retrospectively amending the regulations. You can't become junior assistant engineer from 2006 when the regulations did not permit such a transfer. If I accept your argument, that means you're a JE and AE from 2006 when the regulations did not permit of such a transfer. The petitioner was appointed as an assistant engineer, alva? Electrical. Was appointed as assistant engineer, electrical. Wait, the order dated 29th of September 2010. The petitioner is, however, challenging this very endorsement, contending that he should have been appointed as a assistant engineer electrical with effect from date 16/5/2006. The basis for this claim is that the petitioner was appointed as a junior engineer, and since in 2003, alva? 16/5/2003, and since he was the holder of an engineering degree, he was eligible to be appointed by way of transfer as an assistant engineer. He contends that the regulations till the year 2010 stipulated that in order to be appointed as an assistant engineer electrical by way of transfer. A junior engineer, a candidate should have put in a minimum service of 7 years as a junior engineer. But this regulation was amended on 26th of July 2010. And the eligibility condition for putting in service as a junior engineer was reduced from 7 years to 3 years. The petitioner contends by virtue of this amendment, his date of appointment as an assistant engineer would have to be considered as 16/5/2006. That is the date on which he completed 3 years of service as a junior engineer. In my view, this argument is unacceptable. In the year 2006, the regulation stipulated that the junior engineer electrical would put in a minimum service of 7 years would be eligible for being appointed as an assistant engineer by way of a transfer. It is thus clear that the claim of the petitioner that he should be appointed as an assistant engineer electrical with effect from 2006 cannot be accepted, since there was no provision for such an appointment in the year 2006. A subsequent amendment to the regulations reducing the minimum service to 3 years would not lead to a right in the petitioner to claim a retrospective appointment as an assistant engineer electrical with effect from 2006. The only effect of the amendment made in the year 2010 is that junior engineers as of 2010 who had put in a minimum of 3 years of service would also be eligible to be considered for appointment by way of a transfer. This amendment would basically inure to the benefit of JEs who had put in 3 years of service as on 26th of July 2010. And this cannot lead to a situation where the petitioner can claim a retrospective appointment as a junior assistant engineer electrical with effect from 2006. I therefore find no merit in the petition. The petition is therefore dismissed. Last time ಕೊಟ್ಟಿದ್ದಲ್ಲ time ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
I was working my lord in the government and the post of my lord is by promotion from the who are already working in the government.
You were working as a
waterman.
And what was he?
He is a newly recruit, my lord. He submitted an application and was issued by the government and was selected. I challenged the selection, my lord, before the higher authority under the transfer line. And my lord, his appointment was set aside.
Where is that all? Which is it? What is it challenging? Annexure H.
Annexure H. Lord, page 33. ಈ ಸಂಬಂಧ ಉಲ್ಲೇಖ ಮೂರರಲ್ಲಿ ರಾಮಕೃಷ್ಣ
ಅವ್ರನ್ನ ಏರ್ ಮಾಡಿದ್ರ ಒನ್ ಇಯರ್ ಮಾಡಿದ್ರ ಈ ಆರ್ಡರ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ?
Lord, he has filed objections, my lord, annexure G.
Annexure?
Annexure G. Page 30.
Where is that government order which says that?
My lord, I have produced it, my lord, the statement of the. Page 17. Lower portion, my lord, page 18. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಕಾರ್ಯಾಲಯ ತುಮಕೂರು 19,2005 ಇದರಲ್ಲಿ 18ರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ನಲ್ಲಿ ಹೀಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಡುವ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಖಾಲಿ ಇದ್ದ ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಮತ್ತು ನೀರು ಹುದ್ದೆಗಳಿಗೆ ಅದೇ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಅರ್ಧ ವಿದ್ಯಾಭ್ಯಾಸ ಹೊಂದಿದ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಉಪಯೋಗಿಸಿ ಅವುಗಳಿಗೆ ಪದೋನ್ನತಿ ಮೂಲಕ ಖಾಲಿ ಮಾಡಿಕೊಳ್ಳುವುದು.
When was he appointed?
My lord, he was appointed on
98.
2005. 18/8/2005, annexure B.
Your name is Ramkrishna.
My name is Ram.
When did you? He was appointed in 2005. When did you file the appeal? Because this order is passed in 2011. He had worked for 6 years by then. Correct, but he has worked for 5 years.
Immediately I have challenged.
ಸರಿ, ಬಟ್ ಆದ್ರೂ 5 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದಾರಲ್ಲ ಅವರು.
ಈಗಲೂ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅವ್ರು ಮಾಡ್ತಿದಾರ?
ಅವರು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನಾನು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. I have challenged it immediately.
You are still working? ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರ? So there are 2 bill collectors now. ನೋಡಿದ ರವೀಂದ್ರನಾಥ್ ಇದು? ನೀವಿದ್ರೆ ಇದರಲ್ಲಿ? Both of you can work, isn't it? Why are you litigating?
If I am promoted and if my promotion is undisturbed, I have no objection.
No, your promotion was given pursuant to Annexure H, isn't it? So from 2005, if he is working, why do you want to disturb him now after nearly 20 years?
As far as I am concerned, if I am civil, my lord, I do not want to set aside his appointment.
No, your promotion can only be with effect from 25/7/2011.
It dates back, my lord, to the date of my appeal.
ಅದು ಬರ್ದಿಲ್ವಲ್ಲ ಆರ್ಡರ್ ಅಲ್ಲಿ, ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಲ್ಲ?
ಪದೋನ್ನತಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸಲು ಆದೇಶಿಸಿ.
So therefore it can only be prospective from 2011.
My lord, I have no grievance regarding his appointment. My grievance is, my lord, that I am required to be promoted and that is.
But are you sure that he is working?
That is true, my lord. Now both of them are working as bill collectors.
I will record a statement and dispose it off. Because tomorrow you should not come back and say that he should lose his job, only then he'll get a promotion.
The lordship may save his appointment. Because there are 2 posts, one that of waterman and one that of bill collector. Bill collector's post was required to be filled by promoted.
No, there's only one post of bill collector.
Oh.
And if you are to be promoted, he has to be displaced.
ಇದರಲ್ಲಿ ಅವರಿಗೆ ಎಂಟ್ರಿ ಮಾಡಲು ಕೊಟ್ಟಿಲ್ಲ.
Your third respondent's promotion will be subject to the result of the writ petition ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. ಈಗ ನಂದು writ petition ಅಲೋ ಆದ್ರೆ my promotion ಇರ್ಬೋದು.
But ಇಬ್ರು ಕರೆಕ್ಟ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ, you sure? Because suppose I dismiss the writ petition on the ground that he has continued as bill collector for the past so many years and you are also promoted.
ಅಲ್ಲಿ ಎರಡು ಪೋಸ್ಟ್ ಇದೆ, ಅದು ಅವರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ.
correct.
I don't want him to lose his
No,
job.
I'll protect his job, provided there are 2 posts.
My lord, I understand there is only one post of bill collector and one post of waterman.
And now will there be 2 bill collectors now?
My lord, they should have recruited him as a waterman.
ಆಗೋಯ್ತಲ್ಲ ಇವಾಗ ನೋ ವರ್ಕ್ ಫಾರ್ 6 years. ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ನೀವು ಬಿಲ್ ಕಲೆಕ್ಟರ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀರಾ ಅಂತ? But this order does not really remove him from service.
This does not remove him from service. That, my lord, reduce my benefit. Lordship may save both, my lord. If there are 2 posts, some adjustment, my lord, your lordship may direct the Ram Panchayat to make.
I don't think the CEO has heard any of you. He has simply passed the order.
I prefer not to find his objections.
ಅಷ್ಟೇ, ಆಮೇಲೆ ಯಾರನ್ನು ಏರ್ ಮಾಡಿಲ್ಲ, ಸುಮ್ಮನೆ ಅವ್ರ ಪಾಡಿಗೆ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಯಾಕಂದ್ರೆ 2006 ಅಲ್ಲಿ ಮಾಡಿರೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೀವು 2011 ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
Immediately, my lord, I have petitioned him in 2006. Then, my lord, he files his
What was your prayer?
He files his objections in 2006 only.
Anyone? The petitioner was appointed as a bill collector pursuant to the resolution passed with the Gram Panchayat on 6/7/2005. It is contended that this appointment was also informed to the Chief Executive Officer on 18/8/2005. Thereafter, the third respondent here preferred a petition questioning the appointment of the petitioner as bill collector and contended that as per the government order dated, the order dated
10/1, circular, my lord, dated 10/1/2005.
10/1/2005. There was a mandate for the Panchayat to fill up the vacant post of bill collector by promoting the duly qualified waterman. It was his case that this government order was overlooked and the petitioner had been appointed. Nearly 5 years after the appointment of the petitioner was made, the impugn order has been passed, directing the promotion to be accorded to the third respondent as stipulated in the government order dated
10/1/2005.
10/1/2005. Right, next area.
Next, R3/4.
Next, R3. The impugn order, though directs promotion to be given to the third respondent as a bill collector, it nevertheless does not disturb the appointment made to the petitioner. It is also submitted at the bar by both the counsel that the petitioner has been working as a bill collector since 2005. It is therefore clear that for the past 18 years, the petitioner has been working as a bill collector, and pursuant to the impugn order, the petitioner has also been promoted as a bill collector.
Respondent number 3.
In the year 2011. Since the services of since the appointment of the petitioner was not set aside by the Chief Executive Officer, and since he has been continued as a bill collector, without being disturbed, it would be appropriate to dispose of the writ petition by directing the respondents to continue the petitioner as a bill collector and at the same time also continue the third respondent as a bill collector pursuant to the order of promotion granted to him pursuant to the order passed by the CEO on 25/7/2011. It is needless to state that since the petitioner has been working since 2005 and the third respondent has been promoted only on 25/7 pursuant to the order dated 25/7/2011, the petitioner would have to be considered as senior to the third respondent. That petition accordingly disposed of.
What's the detail matter? What's the number 74? There is one.
ಎನ್ನೇದಲ್ವಾ ನಾಳೆ ಮಾಡೋಣ ಐ ಹ್ಯಾವ್ ಮೀಟಿಂಗ್ at 5 o'clock. ನಿಮ್ದು ಆಯ್ತಲ್ವಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲಿ ಶಿ ವಾಂಟೆಡ್ ಟು ಆರ್ಗ್ಯೂ. ಮಂಡೇ ಬರ್ಲಿಲ್ಲ ಅವರು ಯಾವತ್ತಿಗೆ ಯಾವತ್ತು 22nd. You get ready and argue. You get ready and argue. I've been too indulgent to you. This is the reason why, because I accept your request every time. You start argument. Let us see. If you have any difficulty, then I'll adjourn it. I'm instructing you. You start arguing. Shall I take it as heard? You file a written argument, I'll consider. Twice I have adjourned the matter for your appearance. Today passed over twice. Then that's why I passed it over. Alla ನೀವು busy ಇರ್ತೀರಾ, I'll reserve it. File written arguments tomorrow. Costs 60. ಕೊಟ್ಟಿದ್ದಾರೆ ರೇಟ್.
Next week, 24.